Corrections, let everybody know who's here. So starting over on the far left, Representative Fry, if you wouldn't mind.
Yes, thank you. Good morning, colleagues and guests. My name is Eric Fry. I represent House District Work. That's part of Bangor and
Hello, my name is Eric Jorgensen. I represent House District 41, part of Corp.
Good morning, I'm Jeff Timblake, represent District 75, Turner Leagues at Federal.
My name is Tom Lindsay, I represent District 71, Council Maloney, West Paris.
Good morning and welcome. I'm Peggy Rockwell. I represent part of Lewiston in the House and the House Chair of the Appropriations.
Good morning. I'm Linda Valentino, and I represent State Senate District 31 in Suffolk.
I'm Kate Grant, and no one cares about the numbers but us. I represent Gardner and Farmingdale in the House of Representatives.
Good morning. I'm Linda Sanborn. I represent part of Gorham.
And I'm Representative Bob Nutting. I represent the towns of Oakland and Sidney.
And good morning, I am Linda Starofsky, and I'm proud to represent individuals in House District 28, which is part of Scarborough.
And Jim Hampers, the Senate Chair, Senate District 19, 13 towns in western Maine. Committee members, you've got your green packet there, a whole mess of reports and so on and so on. And don't forget to fill out your sheet on the page and pass this in. We're going to start right off since financial orders is not in order this morning. We go right into district attorney positions. Come on up. Tag team.
Yes.
Good morning, Attorney General Mills.
Good morning.
What, Assistant District?
District
Attorney. Sorry, Nate Maloney. Good morning.
Thank you. Good morning. If I may,
Yes.
Janet Mills, Attorney General, and I'm a member of the Maine Prosecutors Association. As such, of course, the DA's budget is within my budget. And in that context, we've had several discussions about the allocation of new assistant DA positions. First, there was some question about whether or not the request in the budget was a prospective one, or whether it applied to the 10 new positions. And I believe by consensus, we applied the policy to the 10 new positions in the current budget. And we thank you, the DAs, on behalf of all the DAs, thank you for those positions. They are very, very much needed and very welcome. So the position policy I've just passed out was by consensus of the DAs and myself, and was arrived at a couple of meetings. We looked at caseload figures and tried to factor in other issues as well. For instance, the geographical disparities among the districts, the travel time, the number of courts, population, and whatnot. Based on all those considerations, and by unanimous vote, the Prosecutors Association allocated 2 of the additional positions to the York County DA's office, District 1, 2 of the new positions to District 2, which is Humboldt County, one additional position to District 3, which is Androscoggin, Franklin, and Oxford counties, 2 of the new positions to District 4, which is DA Maloney here in Somerset and Kennebec counties, 1 additional position to District 5, which is Penobscot and Scapa, Chris Nolan. 1 additional position to District 6, which is Jeff Roswell, which is the 4 coastal counties, Lincoln, Saginaw, Waldo, Knox. And 1 additional position to District 8, which is Todd Collins of Worcester County. By agreement with Matt Foster, the DA in District 7, he felt he required no additional positions, so there was 0 there. So that's the allocation agreed upon by the prosecutors of those 10 new positions. The policy, and then those positions are being advertised now, and offers are being made. Actually, a couple have been hired, and the rest are ongoing. Policy is based primarily on caseloads. As the memo indicates, however, caseloads are only part of the story. For instance, some DAs spend a lot more time screening out cases, misdemeanor and felony cases, than other DAs do. Some DAs docket in the computers traffic tickets, criminal traffic tickets. Some do not. So the computation of caseloads can vary and skewer the figures and the averages. Also the number of courts. When I was DA of Andrew Scott in Franklin Oxford County, we had 9 trial courts to cover. There were 6 district courts in that district and 3 superior courts. And conflicts in travel and the allocation of resources is much different than, say, in Cumberland County or York County, or Aroostook County, where you have 2 superior courts and several district courts with great distance to travel to get in between them. So all those things were discussed at the meetings. Well, they're not all objective criteria. The most objective criterion is the caseload figure, and even that is squishy because of the factors I just described. So I hope I can answer any, maybe Maloney can answer any other questions that you might have. I hope this memo satisfactorily responds to the question you made.
And I'll just add that when we came to ask for the positions, I brought cookies. And so I thought I would bring my cookies again because I'm not asking for something. I just want to say thank you. And so it might be nice to actually have a thank you instead of always being asked for things. Chocolate, peanut butter, oatmeal, coconut. That's what's in the 14-pounder.
Congratulations on doing a DA Maloney for winning a week-long jury trial last week against a teacher charged with sexual abuse of a minor, which was pretty important stuff.
Strangulation.
Strangulation, domestic violence.
As you were going through the list, your voice dropped off on the last position, and I didn't catch where. I was trying to keep notes here as to who was going or how many were going where. Like you had 2 in York, 2 in Cumberland, 1 in Scott, Oxford, Franklin, 2 in Somerset, Kennebec, 1, and I lost my notes there.
1 in Penobscot,
Penobscot, okay, 80s, yeah.
1 in
4
District,
coastal,
yes, 1 in District 6, which is, that's coastal.
yeah.
0 in District 7, that's Washington Hancock.
0 in Washington.
That's correct.
Oh, really? And the reason on that was?
Because the caseload numbers were low and he agreed he didn't need another body.
Really?
That was the unanimous vote. And 1 in Aroostook.
And the determination as to where they were going was a vote of?
All 8 district attorneys.
Okay, thank you. Questions, committee?
Thank you, Senator. Good morning. So I just to confirm, it looks like in terms of the distribution of the assistant district attorney slots, that's primarily within the district attorneys unless there's a conflict, and then that's when the attorney general might come in. Would that be correct?
That's correct.
And I don't think there's any dispute this time in terms of the allocation of the 10. Is that right?
It was a, as they call it, robust discussion. Unanimous vote.
Right, within the process. So this allotment, and this goes, I think, to the senator's question, it was amongst the DAs that was able to be happening. And as I have been able to pick up, I understand that some of the, we had received some numbers, I think, from the president of the district attorneys, District Attorney Anderson, back when we were hearing about this, for the, look like this, for folks that had these different case numbers that were pulled. And those numbers did not include drug prosecutors, at least according to this. They just included DAs and ADAs. As I understand it, the AG's office is targeting the 2 new drug prosecutor positions that we authorized to help in places like Washington County, Hancock County. Is that right? So, as I understand, there might be a full position planned.
That hasn't been decided.
Okay, but is that part of the thought process at least?
That was not part of the vote on where to allocate these 10 positions. There was some discussion about the drug prosecutors, and they have not been hired. We're advertising for them now. We have drug prosecutor coordinator position in the state, but we make them as well. So a lot depends on who we hire and where we go. But the focus has always been, and will be, on the I-95 corridor to stop drug traffickers from getting to other parts of the state, such as Washington, Maine, Washington, Penobscot, counties. So the focus will be on the I-95 corridor. There was some discussion about that, particularly in respect to Andrews County, where there's a pretty obvious need for drug prosecutions. The caseload for the drug prosecutors dictates that. The allocation has not been made. There was discussion about it, but it wasn't a primary part of the decision making on these positions. There was also discussion of some of the offices having special funded prosecutors. There's an OUI prosecutor that will probably go to District 5, hence Chris Allen's district would be one of the new positions, but understanding that there will be a position for OUI prosecution, because he does a lot of that. There's a specialty court in D.A. Maloney's district. She has the Veterans Court, the Disorder Courts, which although caseload-wise is minimal, the number of cases, work-wise is pretty intensive. And they receive cases, they receive clients, defendants accused from other parts of the state. And that was all part of the discussion too. And that's why she, for instance, would be getting 2 positions, Chris Allen would get 1.
We did all agree that we wouldn't apply for the OUI drug prosecutor, the OUI prosecutor position, that we would just let Chris apply for that.
So thank you for the information on the drug prosecutors. I certainly didn't need to suggest that it should go to a particular place. Obviously, this is all talking courtrooms where we talked to attorneys about where people might go. And so I certainly didn't know what was going to happen, but I hope that we part of the calculus for those choices. And let's talk about Penobscot County, because that is obviously something being prepared for. That's right. And if the primary calculus was caseload number, by the numbers that were provided by the district attorneys, the Penobscot calculus caseload number was 780. The second highest caseload number would have been Androscoggin, Oxford, and Franklin at 677. Those 2 districts only got only received 1. Meanwhile, districts that had less of a caseload, it arguably had access, like let's say Cumberland County has access to a law school. It's my understanding that OUIs aren't really prosecuted as severely as Penobscot County in terms of what the BAC number is to do an OUI versus a drug into danger. So I understand that as part of the calculus, there's a grant position that may end up going to Penobscot County for 3 years for just OUIs. And then that position may be reauthorized, maybe not. So then that's gone, and Penobscot County, with the proposed distribution, will be back up to 706 cases per attorney for the numbers that were provided by the district attorneys. Penobscot County still has about 150 more than District 1, so Cumberland County, York County, Somerset, Kennebec County, Knoxville, Lincoln County, 250 more than Washington, Hancock, 200 more than Brewstick. So I guess I'm just, if caseload number was the primary consideration, even if you had an OUI prosecutor that can only do OUI, so they can't do domestic violence assaults, they can't do drug prosecutions, they can't do the thefts and the burglaries that are sort of spawned by people who are looking for money to buy drugs and to support their malfeasance. Sure, maybe it can be done with ancillary to the OUI, but so it's only going to provide help with the OUIs. So how is it that that reconciles with the caseload being the primary determiner of which counties get which laws?
Well, one thing we discussed too was the differences in analyzing the caseload. What goes into the justice system varies from district to district as well. What you get from the court system is one set of caseload statistics, and what you get from the prosecutor's computer system is a different set of statistics. And also analyzing the different policies on screening cases out, and what goes into the system in one district may be different than what goes into the system in the other districts. And sometimes screening out cases, as mentioned in the memo, takes a lot of time as well. So we try to have that sort of subjective discussion, not solely on raw numbers, because raw numbers are not totally accurate. They're apples and oranges sometimes. And DAL agreed with this allocation, so I guess on more specifics related to his district, I defer to him. But he also has, going back to the drug prosecutor, which is already a drug prosecutor situated in Knoxville County, which takes the load off of him, Chris, somewhat. Whereas in Worcester County, there is none, for instance. So there's that discussion. And the caseload numbers would include, I believe they include the ones we have, including drug cases. They were a factor that they were taken out, so.
And it was a difficult decision because there were so many factors to include. When we looked at the number of cases declined, for example, there were districts that declined far fewer cases than other districts. But the ones that are declining more are putting a lot of time into screening cases up front, and that takes a lot of energy as well. So we tried to factor that in. We did find out, for example, my district doesn't put into the computer system any criminal cases that arrive on a ticket. We only put the cases in where we have to file an actual complaint. Other districts put those tickets into the computer. So we realized that it was difficult to compare our numbers because we weren't processing the cases in the same way. So then we started to talk about, well, what would the people do in the districts if they were given the position? What were the needs that weren't being met in each district? And well, you're absolutely right, an OUI prosecutor would be for 3 years. In my district, I have a DB prosecutor that's part of these numbers. That person's included in my numbers, but I apply for them every year. There may be a year I don't get it. That was also true for York County. There's a position that DA Slattery applies for every year. She may or may not get it 1 year. And then I think she also has another position that can only do appeals that's paid for by the county. So all of these things we tried to take into account. And believe it or not, at the end, what was kind of heartening is that we had a bunch of people saying, no, not my district, yours, no, not mine, yours, and everyone trying to give an extra position to somebody else because everyone had so clearly advocated for why their district had needs, and we just came to a consensus. We never actually voted, it was just everyone came to an agreement, this is where they should go.
And I'll talk with Chris about how it is he arrived at where he arrived at. Since I deal with these prosecutors on a daily basis, and I see what the impact is of having the highest caseload before and after these numbers. And with the drug prosecutors, I think Cumberland County might have there's 4 other drug prosecutors, or 5 of them that we didn't talk about. So, if I-95 corridor is one, I assume York, Cumberland, so those numbers would also go down as well, including Knoxville counties, which does have access to at least half of the prosecutor now. So I guess, I made the mistake, I guess, of going by numbers that were provided by the district attorneys. To sort of, so I hear that there's these soft factors, but I'm also hearing that there isn't a way to quantify them. I'm also suspecting that if what I'm hearing sort of rumblings that the district attorneys might come back for more money at some point in time for prosecutors because the 10, the budgets were 22, not 10. And so we're going to have to somehow figure out, if the argument's going to be what it just was, which is, well, we need to reduce headcount. If now we need to reduce headcount and take into account soft factors, I guess it would be helpful to know, because if district attorneys know what the soft factors are, they can articulate them to the group, to the collective, to come to a number. But I think it would only be fair that that same sort of soft factor articulation should come to the entities that are legislating money to be distributed to try to make it easier for prosecutions to happen in districts. And so I guess that's a comment, and I guess it's a request of sorts that to the extent that we do have soft factors, it would be helpful to know how this is working. So I go back to Chris and say, geez, Chris, you made a great decision. Or Chris, what the heck? You still have the highest caseload by the numbers that the legislature has. Why does that make sense under the circumstances? So any sort of information that can be generated to help us understand that would at least be interesting to me, and it might be interesting to some of these counties that are also having conversations with their prosecutors about how hard their prosecutors are working, you know, to sort of understand what happened. I appreciate your time today.
We'll relay that message to the Prosecutors Association.
Representative Jordan?
Thank you very much. I'm glad to see there's a policy. It's great to have a policy in place, and it sounds like, you know, it's working. But I'm curious. My question really comes around the idea: would it be possible, do you think, to standardize some of these counts? I mean, if some people put in tickets versus drug prosecutions or whatever, I mean, could we make it so every county has apples to apples, so we can actually kind of handle a case like that?
And that is something we're talking about, trying to standardize more what we do. Yeah, I'm the one who doesn't put the criminal tickets in the computer system. I don't want to because it's more work for the staff, so I don't want to give them additional work to do. Others who do put that information in, they feel like, well, they figured out a way to put it in and they don't want us to stop putting it in. So it's always a debate, there's always a back and forth, but we have been doing, we have had a lot of discussions around standardizing things in general, trying to standardize more things. And so I know we'll continue those discussions. It's difficult to get people to do things exactly the same way. Which is why, really, what I found heartening about the whole process is the fact that you had 8 people with very different interests, and Attorney General Mills was there with us discussing this, and it was civil. We didn't take each other's heads off. We actually talked well together and came to a consensus, which I thought was amazing that we were able to do that, being all as different as we are, that we were able to come to that consensus.
Thank you.
The standardizing of reporting is exactly where my head was going also. It's like,
Yeah.
Add to that. You know, I was district attorney for 15 years for 3 counties. I know that my ways of doing things were different than other DAs. And my priority was to screen cases at the very beginning, for instance, with the misdemeanors or felonies, and using the grand jury process on occasion to screen out cases. Sometimes that took a great deal of time, because my policy was once you approve a charge, you better be ready to try the case the next day, have all the evidence lined up, all the witnesses interviewed and whatnot. It's not always easy to do that in the busier counties, where you have dozens of police departments and sheriff's departments and game wardens coming to you with tickets and complaints all day long. But now I was able to do that in some counties better than others. So those are some of the soft factors that we're talking about, really. But I think there are good policies underlying those soft factors. It's hard to quantify the workload because it's not just case numbers. One OUI case would take 3 days to try, whereas a manslaughter case, even an arson case, might be tried in 1 day. I've tried murder cases in 3 days, jury selection to sentencing, verdict. Sure. Look at that. Now you judge obviously, probably 12-hour days, but you know, the amount of time consumed and work involved in the case varies from case to case. Whether they're tried or they're pled out in arraignment, you know, that's the time to go about the case.
Thanks, sir. I actually forgot a question I had. I know that DA Anderson had brought up that traffic tickets are being billed by the officers themselves. She doesn't, at least she didn't have a prosecutor doing that. And I believe that DA Elmy is now doing the same thing. He just stopped providing a prosecutor, or at least that's what he said he was doing. And in fact, I ran into a trooper that indicated that he was in perhaps going to train officers how to handle their own cases. Under other prosecutorial districts that are making that decision to move away from some of these, if there's civil violations, it's more likely than not that somebody texts while they're driving or speed or what have you. Are there other districts that are deciding to do that because of man policy?
William Cumberland's been doing that for a little bit, and it's a topic of discussion, it's not without debate or.
I considered moving to that model. I brought it up at a chiefs meeting, and the chiefs in my district were very much against it. They really strongly wanted an assistant district attorney at traffic court. I also talked with the judiciary in my district, and they were even more strongly against it. They even more so want an assistant district attorney there, so I decided not to go that direction. What I do, and it's difficult. I mean, I have this month in Kennebec, we have traffic court 4 days. 4 days that I have to send an assistant district attorney, and then in Somerset, I have another day. So that's 5 days of work that I wouldn't have if I wasn't sending an assistant district attorney. But I'm hearing from the judiciary and from the chiefs, it would be far more difficult, and people would not be receiving the due process that they should be receiving if we weren't there. So what I do, I try to only send one ABA. There are times when the list is so large that I have to send 2 because I know one person can't handle it. I've asked each chief to send a representative of their department to help us in negotiating their department's cases, because if I didn't have that, I'd be sending even more. So I try to just send one, and then I send interns. And I recruit heavily to get people to do internships. I can only pay for one intern, so I try to get unpaid internships through Maine Law School as an externship. And I spend a lot of time recruiting so that I can have people go, have enough people in court to handle all the cases and to answer all the questions.
And I just add also on caseload issue, workload issue, not caseload issue. The UCD, Uniform Criminal Docket, has been implemented in several counties now. The DAs are telling me, although I don't have direct experience with it, they're telling me that that's increased their workload rather than decrease it. And it's a bone of contention between the DAs and others in the system and the court system, why that's being done, whether it's going to be more efficient or less efficient. So that's one of the factors. Some districts have it, some districts don't. Some districts are just starting to have it. It's a consolidated court kind of system. The second thing that's been brought up at every meeting I've been to for 2.5 years or more, and that is pre-trial discovery motions that have become extraordinarily time-consuming. The new mode for defense attorneys, and I've been there too, is to ask for every videotape and every even tangential piece of evidence to be provided in discovery before trial. And that requires the DA to watch sometimes 8 hours of videotape on a particular arrest or a particular investigation before providing it to the defense counsel to make sure they know what's in it. Some of those things have become much more time-consuming than ever before.
And now there's booking room videos, there's body cam videos, there's dash cam videos, and
YouTube.
But what we have to provide them. And that's the problem, is part of the unified criminal docket says that any videotape of defense has to be given as part of automatic discovery. So even if I look at it and say, there's nothing of evidentiary value here, why does anyone need this? I'm not allowed to make that decision for the defense attorney. The defense attorney gets to make that decision on behalf of his or her client on their own. They're entitled to see it. They can't see it unless I provide it. So we have to get all of these videos from the police department, and I just had a meeting with all of my chiefs, which was the only meeting since I've started that every single department sent at least a chief, if not the deputy, and the sheriff, and the chief deputy sheriff too. Every single department was represented, and it was about discovery and about copying these videos and how time consuming it is and how burdensome it is on their departments. But if we don't provide it, we lose the case. So it's an extremely difficult topic. The 911 tapes, I absolutely have to have those at least in every domestic violence case, because I need to know, why was this call made. Certainly if the victim made the call, then I definitely need it. But even if it was a neighbor that made the call, well, what caused you to call 911? Must have been something pretty dramatic. That's a tape that I need. That's very burdensome on the departments, and I understand that.
Other questions? You're uncharacteristically quiet.
She's waiting for Saturday when we're going to hear her sing, I hope, the sexual assault prevention dinner.
No, alas.
No?
We're happy to take back any other suggestions from the committee, any other requests from the committee about what other information you'd like to get from the DA's position.
Circling back to the Durham prosecutors, you said that decision has not been made yet. There's two of you. You picked the application.
I am, yes, sir, Jeff.
Okay, two positions have been authorized, and that decision will be made when?
First thing I want to do is hire a new drug prosecutor coordinator, Jamie Garrett, who's super. He's one of the federal governors, one of the U.S. Attorney's Office, my laws to Maine. So we've advertised for that and for two new positions. We're interviewing for all three. So there's no decision. And in good part depends on who's situated where, and case loads are the main thing there too. The case loads are heaviest per drug prosecutor in Amherst-County, Oxford, Franklin County. We haven't been doing Franklin County recently, the last year or so. But Oxford and Amherst-County have a huge case load, so that's the first target for my purposes.
And the hopes for filling those positions, timeframe?
It's a position for which I carefully screen. I think drug prosecutor positions, like drug agent positions, are, you have to be very careful who you hire. You make sure they're the right kind of person, and not just from experience, but from character and anything like that. I know the Department of Public Safety is doing the same thing with the new agents that they're advertising for, screening very carefully. So I don't have a deadline. I just want to make sure I hire the right people with the right job characteristics.
Okay, how many hopes?
Hopes? Hopes within the month or
You
two.
keep pushing here.
Within a month or two, yeah. I could, yeah, but,
Thank you very much, Mr. Chair. Since we're talking about the drug prosecutors at this junction, there's been a lot, obviously, in the newspaper. You attended the summit that was being held, which I believe was a closed-door summit, so we don't really have a lot of details on that. I'm just wondering, would you have more information for us at our October meeting if we actually scheduled something on the agenda to talk about what was being done between your office and the administration, and whether or not you were looking for additional appropriations or a shift in appropriations? Is that something that everybody would be prepared to talk about openly? And of course, there's been a lot in the newspaper about this secret agency at the, public safety that we don't know about. And I just think that would be something that is making headlines, and it's very disappointing also to be on a committee and then read about something in the newspaper. So I'm hoping we might be able to coordinate that between your office and public safety for the October meeting to find out what really is going on.
okay. And I just spoke about this at length to the Maine Medical Association on Saturday about the opiate, particularly the heroin problem in Maine. To try to get the doctors on board with looking at prescribing procedures, protocols, becoming Suboxone prescribers, and all that. We had a great discussion just Saturday on that issue. And right now, I'm also missing a meeting at the U.S. Attorney's Office where U.S. Attorney Delahanty is organizing 3 task forces that I expect to be part of. Listening, Tom, and one on treatment, one on prevention, and one on law enforcement. And in terms of prevention, Dan Perry of the U.S. Attorney's Office and myself and Skip Gates, who's an advocate whose son died of an heroin overdose a few years ago, we're meeting with the Maine school management people in October, trying to get into the schools a little more to get the presentations authorized and scheduled, to make sure they're not qualms on the part of the school board and superintendents and principals about us presenting on the topic of heroin, because it's affecting every age group and every demographic in Maine. In terms of law enforcement, we're working with the U.S. Attorney's Office on that, and talking with the MDEA about the new hires and where they can go and what they can do. So it's all kind of preliminary there. As for the Fusion Center, I'm not in charge of it. We went to one meeting 2 or 3 years ago. I do that. And that's under Dept of Public Safety, and they're going to say what they do. But I'm glad to make the inquiry for it and ask them to report to me in October.
Okay, well, as a follow-up, Mr. Chair, I would like to see this on the agenda and put the public safety on the Attorney General's office, the Fusion Center, and maybe even the National Guard, and see how what you're doing relates to the budget that we've done, and whether or not you're going to be looking for supplemental appropriations or anything. So I think that would be timely to bring that up and to get everybody in and find out what's going on and what the money is involved really to do it, and what agencies are involved. Thank you.
Representative Strong?
Mr. Chair, yes, I'm just a little confused with like a little clarification. Of the 10 new district attorneys, what portion of their caseload would be related to substance abuse?
Well, in most counties, the Attorney General's office, the Assistant Attorneys General, who are part of the drug task force, will be handling drug court, for instance. In Worcester County, the local DA's office handles all the drug cases. There's to be a new drug court, I believe, in Offset County. Our Assistant AG will be involved in that. Our Assistant AGs are involved in drug court in York County and in Cumberland County in particular. Elsewhere, DA Maloney handles the Veterans Court and co-occurring disorder court with her own people in the house, which is very time intensive. Co-occurring disorders involve substance abuse and mental health issues, which you probably know. So does that answer your question? I'm not sure.
So I think that helps. I guess I'm a little confused as to why Washington and Kennebec County aren't getting an extra district attorney. I'm just trying to tie that together because I know that of all the states, Maine has been known to have the highest rate of prescription drug abuse treatment in the country, which then follows that we have a very high rate of prescription drug abuse. And Hancock County in particular, I believe, had the highest rate in the state of Maine. So if we have that much of a substance abuse problem in that area, I guess I was just trying to get a grasp of the court system in relation to that.
I can only base my judgment on the caseload, the drug cases in particular, the number of arrests and the number of prosecutions. And in that respect, they all reflect the same conclusions that you're making about Hancock and Washington County. I don't know about the treatment statistics, substance abuse treatment, but the arrests and prosecution caseload are quite high in Amherst County, Cumberland County, and York County in particular. They're not as high in Washington and Hancock County in the number of cases. And it's partly a reflection of the MDEA presence and the law enforcement presence generally, what we're doing. But again, we're all focusing on the I-95 corridor, which feeds into all parts of the state. But they tend to set up shop, let's say, in Portland, Lewiston, in terms of Augusta, in York County, rent an apartment, start dealing drugs, heroin, pills, fentanyl, oftentimes unbeknownst to the consumer, fentanyl, which is very deadly. And it's easier for them to set up shop in those places right off the I-95 corridor. And that's where we're focusing our law enforcement efforts now. But not to say that we haven't been significant heroin arrests just last weekend in Brewer and other parts of the state. It's a networking thing.
And I can say, of course, we work together. We have to work together. So while there's an assistant attorney general who might be the drug prosecutor for an area, of course, drug crimes are also prosecuted by the assistant district attorneys as well. The assistant attorney generals take the MDEA cases. So those are the cases, but by and large, and some of them take more. It's different district to district. But so I can say, for example, in my district, if Augusta Police Department is the lead on a case, then that case goes to my district. If MDEA is the lead, then Assistant Attorney General Katie Sibley will take the case. So it depends on who the lead law enforcement agency is as far as who takes the case. And of course, drugs are a big part of every crime that we handle, whether it be burglary, whether it be a robbery, and by and large, it's because of drugs that those crimes are occurring. And one thing I always like to bring up, because it's a money issue, since you're the money committee, is with the Veterans Court and the Co-occurring Disorders Court, we have seen Vivitrol and naltrexone produce amazing results. I mean, people who were addicts for years, who could not turn it around, with that is a drug that takes away all cravings. And it's not a drug in the sense that it doesn't give you a high. It just, if you use any substance, whether it be alcohol or heroin or any narcotic, it makes you sick. So there's no high that comes from it, so it's not going to be abused, it's not going to be sold.
It's a once a month.
And it's once a month, it's very expensive, so very few people qualify for it. And I'd love to see that be possible for more people to have access to it. I have an alternative substance abuse program in Somerset County that is with the community. The community runs it because we don't have enough judges to have an actual drug court there. So it's a community-run program. And with that program, we allow Suboxone. It's difficult because for some people they do very, very well on Suboxone, and for other people we've had problems with it. But you can find that people will sell their Suboxone, you can find people who shoot up Suboxone. Never occurs with Vivitrol or naltrexone. So that's the big difference between those two treatment modalities. Suboxone is less expensive, so that's why we tend to use it more.
Representative Maloney, did you have a? No. Okay. Representative Brown?
Thank you. Just going back to Representative Siraki's question, when I didn't hear the answer, is, again, I understand that Washington Hancock has by far the lowest number of cases, and that doesn't factor in that there is half a drug prosecutor that's actually based in Washington. So there is a recognition that there is some need for specific drug prosecutions. And I think that the Hancock County has a drug court, which of course, Comstock County isn't a drug court right now. So I think that there has been some recognition because Washington County, just like Comstock County, is able to use the Hancock County drug court for their drug cases. So I didn't hear that, but I think that's accurate, right? That there is a half drug prosecutor and there is a drug court.
Right now,
like 4 in the state or 5 in the state.
the drug prosecutor from Osgood County is covering Hancock County.
Right, I know there's like a split, like a half and half, if you will, that Pat Larson, who's the drug prosecutor, he does like a circuit where he'll do like
He also has one of the highest cases.
Right, I understand that, but I do think that, I just agree, I think there is recognition that there's specific drug issues, and in that very low number of cases that are presently reflected in the numbers for Washington County, they are still getting a drug court and a however much of a drug prosecutor. They're getting Pat Larson, who's doing the drug cases. Is that right?
Further questions? We've, in the town of Paris, started a substance abuse response team kind of thing. And attended a few of their meetings, and the whole heroin issue. The frustration that comes into that room where we have some addicts that show up, some that are recovering, some that are using currently, mothers, fathers, and the sheriff comes in, we got plenty of police departments. I'm telling you that the frustration that is involved surrounding the whole heroin issue, it's well expressed in the public forums. And the longer I sit through those and the more exposure I have, the more I realize that it's not a one-prong, but a three-prong approach. But the public is frustrated, particularly talking DA their parents and how try telling that to the person whose house was just broken into, and their whole sense of security is shattered. You know, and saying, oh, well, it's just a German problem. You know, yeah. I don't
I've been to
have
those meetings as well, and I share that concern. The one thing I hear from physicians is there's no place to send it. There seems to be a lack of detox beds. So when somebody's Narcan and brought back to life and they're in the ER, there's no alternative to send them back to the streets, back to the apartment, to overdose again. They need this immediate facility in different parts of the state. We need detox beds, that's what I hear.
And then have the Oxford County Sheriff come in and say, you know, just yesterday, you know, they lost one, but brought two back in the Rumford area, just in the Rumford area. So when you say Oxford County has got a problem, and in my rides with the Oxford County Sheriff's Department, you know, that's what they talk to me about. It's mostly drug issues.
You may have heard about the program in Massachusetts where the police department is allowing people to come and ask for treatment. Chief Gregoire is trying to replicate that program in Augusta, Maine through the Augusta Police Department. And I'm a part of that group discussing how to make that happen. One of our biggest roadblocks is the detox. Where do we send people who come to Augusta Police Department, say they want treatment, that next 48-hour period as they're detoxing, where do we send them? We're having an easier time figuring out how to give them treatment after that, getting them into things like IOP and getting them, having them go to NA meetings and setting up that whole process. But it's those first few days where we're not sure where to send them, and that's a roadblock in implementing the program.
And Paris PD has reached out to him to gain more information as to. But my goodness, we don't even have an NA meeting going in the Oxford Hills area. And hopefully through this whole process, we can at least get one group started. You know, and it's very frustrating. Very frustrating. So Valentina.
Thank you very much, Mr. Chair. Bringing those two items up, also the AGEL program and the roadblock being the detox centers, maybe that's something also to talk about on the October 15th meeting. As it was stated by our chair, it is a three-pronged process. We can't just arrest people, and we can't do an AGEL program if we don't have places to put them. So, I mean, this is a situation, and that's what I was trying to get at originally under the summit. Obviously, if you're looking at this three-pronged process versus just one prong, arresting people, throwing them in jail, there's going to be additional money that we're looking for in supplemental budget. So to kind of give us a headway of what you're looking for, I think also to examine these aspects and any other, if you think about Conotrope, Neotrope, meeting.
Anyone else?
Thank you. Maureen, are you getting all of this? Okay, I it looked like you were writing that.
I guess that's it.
Thank you for your time.
Thank you.
Thank you.
And DHHS, we still wait, right?
Chris is available.
Chris is available. No more than saying his name and he walks in the room. Your timing is impeccable. Good morning.
Good morning. Good to see you all again. You have
It's in the page, you would introduce yourself.
Chris Nolan, Office of Fiscal and Review. I'm sorry. You didn't introduce me between when I was up my desk and when I walked in. Sorry. You have a 8-page package in your binders. It says fiscal year 2015 year-end cascade transfers. A very exciting topic. Make sure you don't pull it out. You see it? So it starts with a one-pager, which just summarizes the general fund and then highway fund year-end transactions. And then the other 7 pages of the document are just the updated status sheets for the 14-15 and then 16-17 May for the general fund, highway fund, and fund health in Maine. So I don't know how much time you have. I can just go over it. If you have any questions, if you have to bump me, I can come back later to answer any questions. So,
Do a quick run through?
sure. So the general fund had a $59.1 million closing balance. Of that positive balance, of that amount, $25.6 million you had already been assuming it was incorporated in the budget. It is the difference, the $33.5 million, which was unbudgeted, which is explained here. And I can show you that $25.6 million that you had assumed, and then the $33.5 million in the status sheet, so when we get to that. So we're talking about, for now, we're talking about $33.5 million surplus that was distributed. That surplus comes from a $30.4 million positive revenue variance, and this is revenue above the May estimated increase that we had budgeted, so that's an additional $30.4 million. Most of that was in the income tax, and I'll go through that revenue variance with you as well at any point. The other component was programs that didn't spend their appropriation and their funds lapsed back to the general fund, and that was $3.67 million. And then there are numerous other accounting adjustments that had a negative impact on that, which left a $33.5 million balance. And so again, most of that is from an increase in revenue above the May forecast, and then a small part from programs not spending money or lapsing the general fund. That money, that 33.5, is distributed first to fixed dollar transfers. And as you may recall, in the budget, we changed how the distribution of the cascade happened. It was in section, originally proposed in section M, that ended up in section L8, which amended the distribution of funds. So as it now stands, a portion was a fixed dollar transfer, $230,000 to replenish the contingent account, $1 million to the loan insurance reserve, and $2.5 million to the general fund operating capital. And the balance of that was distributed 80-20 to the budget stabilization fund and to the tax relief fund for Maine residents. And it's that distribution 80-20, which is what was changed from previous years. The tax relief fund for Maine residents, that was 20%, and then the moving around some things into fixed and et cetera, that was proposed by administration and then modified and enacted by you all, resulted in this final distribution. Just briefly, the highway fund has its own distribution, and it had a $11.7 million, of which 6.8 was revenue positive revenue variance, unbudgeted lapse funds 4.5, and then other accounting adjustments which were positive at 11.7. Given part of that was balanced forward, and part of it is required to increase the budget balance in highway fund, and then the rest is distributed to Department of Transportation for highway programs. I can show you that in the status sheets as well.
Senator Valentin?
Thank you very much, Mr. Chair. Thank you for the information. The $23.8 million that was added to the Maine Budget Stabilization Fund, that brings the balance up to what amount?
111.1.
111.1. And my second question is in regard to the general fund revenue variance. I know we were all anticipating the May revenue forecast when we were trying to complete the budget. And at the time when we received the May revenue forecast, I believe there was a projection that we would be losing revenue of about $32 million. So I guess I'm a little surprised now when the May revenue forecast came out saying that we had to budget for another $32 million in loss of revenues, and then we came out with $30 million more. Especially where we're coming out of the economic cycle right now. It's been a fabulous summer for tourism, for businesses. I'm just wondering, why were we so off on that, and when is our next economic forecast?
The number that you're talking about was a 3-year, 15, 16, 17 combined impact of the May revenue forecast. So what we're looking at here was just the positive variance for 15, just 1 year of that 3-year period. So we had actually, in that 3-year adjustment, there was a positive variance for the current year 15 of $22 million. And the negatives were going to be in, which we accounted for in the budget, we're going to be in 16 and 17. So this is we made an adjustment of $22 million. This is a further positive adjustment for 15. What it means for 16 and 17 will be determined when we get the economic forecast and then do the updated revenue forecast in December.
So it'll be December the next one.
Right. So just going back through that forecasting, it was thought that the positive variance in 15, particularly in income, was going to be one time. So there were negative adjustments in income in 16 and 17. So now that we've added even more to the positive adjustment in income, there's still the question as we move into 16 and 17, is that going to be one time, or is it going to mean just on the income tax side? Is it going to mean that we can turn around and do a positive adjustment to the forecast for 16 and 17? And that's yet to be determined. So, and the sales tax was up, and so that will also be part of the economic forecast and then the revenue forecast before you come back in January and have to consider any kind of additional budget amounts.
Okay, thank you.
Representative Grant?
Thank you, Mr. Chair. Lest you think I lost my voice. I just have a question about the tax relief fund for Maine residents. Could you just refresh our memory as to which Maine residents received that tax relief? And this is in addition to the tax cuts that we gave across various brackets, correct? This was the extra, and how many years has it been since we've actually done this?
Well, I have to get back to you on how that actually gets distributed, but I mean, I know that this additional 5.9 brings the total to 9.6, and I'm not, I'll have to get back to you on how that's distributed, or whether it was actually distributed at all yet, so I'll have to get back to you on the side.
Yeah, go ahead.
So the first is the general fund, and this is just the general fund status, and a lot of numbers, a lot of tiny numbers, but this is just our way of keeping track of all of the changes in both the adjustments to balance, the revenue and appropriations over the course of the 14-15 biennium. The two gray or highlighted boxes just show the additional revenue and the then adjustment in the transfer to the stabilization fund. So with all those changes, the balance at the end of 15 stays the same. with additional revenue coming in and then being transferred to the stabilization fund. So bottom right corner, the 25.6 million is the balance that you had budgeted and are using to fund that carryover into 16-17, balance 16-17. So all those transactions, all those lines, so all the changes that have been made over the last 2+ years in 14 and 15. The next page is 16-17, and it shows in the blue box the balance coming in of 25.6 million, that same balance that you had assumed, and then with the changes made throughout all the session, both budget, obviously the major changes with the budgets, and then the effect of bills that got enacted primarily through the special appropriations table leaves us with a balance that, an estimated balance at the end of 17 of just under 1.7 billion. And of course, we're getting new revenue estimates in December, and any additional requests or not from the executive branch shortfalls for 16 or shortfalls for 16 and 17. So we'll be incorporating the next update of this balance sheet.
Questions? No, seeing none.
Next page is just one page on the highway fund status. Green box, why general fund is blue, highway fund is green, and fund health and Maine is pink is not really known, but it's just a long established color scheme. And also change that to such known. I know why fund health and Maine is pink, I don't know about the other.
Was that covering the appropriations orientation?
No, I checked whether it's constitutional, but it's not. So you see the impact of the highway fund, basically that balance of 11.047, that transferred at the beginning of fiscal year 16, and then the changes, etc., and they have an estimated 17 closing balance of just under 200,000. So they also will have the same process of updating their revenue and also any additional positives or negatives from their allocations that were provided in their highway fund budget and other legislation.
See any questions on the highway budget? Wrap up.
Yeah, I can do Fund Healthy Maine pretty quickly. So, Fund Healthy Maine, you see it's 1415. The shaded box, so Fund Healthy Maine had just over $7 million surplus going to 15. There was in the emergency supplemental, a distribution or an increased allocation of 2.5 million, which would have reduced the Fund Healthy Maine's balance down to around 5 million at the end of 15, but in that gray box in the middle that says other resources and adjustments, when the year closes, the Fund Health Maine recoups money from vendors, etc., and settlements of 430,390, which is a positive to put in the Fund Health Maine. And then the larger number, just under 2.3 million, are programs that do not spend the money that they're allocated from the Fund Health Maine. That money returns back to the Fund Health Maine. So the combination of those two additional sources on closing at the end of 15 brought the balance of the Fund Health Maine estimated back up, or actual to 7.6 million. The last sheet, again, I think is the 16-17, and starting with that 7.6 million, the actions taken for 16-17, in effect, reduced that balance estimated at the end of 17 down to 6.1, 6.2 million. So that, in a nutshell, was the three major funds.
Questions? Seeing none. Okay. Okay, thank you.
You need back, so yeah.
We'll let you know. Thank you. You got a load of paper for us, Commissioner?
Well, I do, but it takes a truckload to bring it over, so it'll be arriving shortly.
You ready to go, or should we hang tight?
Well, I am happy to do what you would prefer. The testimony is on its way, but I can begin with mine.
Why don't we do that? Keep things moving. Because, my goodness, if I release everybody for a short break, it'll be noon 15 by the time you come back.
You might not get them back.
That's right. Introduce yourselves would be great.
Happy to. Good morning, Senator Harper, Representative Rotundo, members of the Appropriations Committee. My name is Mayhew. I am the Commissioner for the Maine Department of Health and Human Services. I have with me Jay Harper, the Superintendent for Riverview Psychiatric Center. I'm going to go through a considerable amount of background just to refresh everyone of where we've been and where we are today. I am here today to discuss the recent court decision related to our appeal of the CMS decertification of Riverview Psychiatric Center, the implications for federal funding, current efforts to recertify the hospital, and the overall quality and performance at Riverview. But before going into the details around this issue, I think it is important to share a bit of background about Riverview Psychiatric Center and the people who they serve. Riverview Psychiatric Center is a 92-bed hospital with 4 inpatient treatment units. It serves people who enter voluntarily, patients who are civilly committed, court-committed patients, individuals needing evaluation from the county jails, and provides outpatient services. The trend over the past several years has been for an increasing number of civil beds to be used by court-ordered or not criminally responsible patients, because under Maine law, these patients have nowhere to go but Riverview. That ripple effect is felt across the adult mental health system, often putting local hospital emergency rooms in difficult situations. Often, hospitals are called upon to provide oversight of persons suffering with mental illness while attempting to find a bed where he or she can be placed within the mental health system. In fact, Riverview has periodically been closed to civil admissions because of the number of individuals needing to be admitted from the courts. Over the past few years, the level of court-ordered and NCR patients have increased dramatically. In January 2011, there were 44 such patients at Riverview. That number reached an all-time high of 62 in April 2012 and has typically been above 50 patients. Today, 41 of the beds are being used for those who came to Riverview via the courts or jails, including those found not criminally responsible, while 39 beds are being used for civil patients. As previously mentioned in current Maine law, Riverview must serve clients with serious and persistent mental illness that are sent to the hospital from the judicial system via a court order. These clients include a direct transfer from a correctional setting for stabilization, those ordered to be admitted by the courts for stage evaluations, those found incompetent to stand trial, those found not criminally responsible for their crime and ordered into the custody of the Commissioner of the Department of Health and Human Services. This group, those deemed not criminally responsible, typically makes up the largest percentage of the court-ordered population. In terms of the hospital's current status, it is important to understand that all hospitals that participate in the federal Medicare and Medicaid programs are subject to federal surveys to ensure compliance with the conditions of participation as a licensed hospital. A complete historical picture is not only helpful, it is critical to understand how Riverview's funding has been and remains at risk. I want to
talk about a budget proposal that came before the legislature in 2012 dealing specifically with this federal funding. The issue of dependence on that federal funding was first brought to the legislature's attention in 2012. In a supplemental budget request, the department made 2 recommendations. First, replace all federal disproportionate share hospital funding with general funds and treat the disproportionate share hospital federal funding like all other state revenue to be included in the revenue forecasting methodology. The intent was to eliminate the annual need for general funds to repay previous year audits, given the fluctuation in the disproportionate share eligible patients, and to create effective financial stability for the hospital. This proposal was rejected by the legislature. Secondly, the department requested to reduce the overall dependency on federal DSH funding by $10 million by replacing that revenue with general funds to cover the costs of forensic patients. The department explained at the time, in 2012, that the state was at significant risk of a sizable audit finding related to the forensic clients being ineligible for federal disproportionate share funds. The legislature chose to approve only $3 million and excluded those deemed not criminally responsible from this funding. Had the legislature acted to adopt these recommendations well prior to the 2013 CMS survey and certification process, we would not be looking at the level of financial risk associated with these federal funds. In April of 2013, the Centers for Medicare and Medicaid Services, CMS, conducted a complaint investigation in the hospital because tasers had been deployed against patients. The concern identified by CMS was that the hospital looked more like a correctional facility than a hospital. In June of 2013, CMS, as part of its follow-up survey, identified numerous deficiencies at Riverview related to quality and safety and informed Riverview that if it failed to address these deficiencies, RPC's certification would be terminated effective September 2nd, 2013. Their major concern was the hospital's use of correctional officers on the acute forensic unit. In addition, they had other areas of concern, including medical record documentation, quality indicators, adequate staffing, and some minor physical and environmental repairs that needed attention. Over the course of July and August, 3 plans of correction in POC were submitted to CMS. The first 2 were rejected. In discussions with CMS personnel in both the regional and national offices, Riverview was strongly encouraged to change course and establish what is known in the regulations as a distinct part unit. At the time, Riverview was not inclined to remove the correctional officers from the unit, from the intense inpatient forensic unit, because of the current patients in the acute forensic unit, Lower Saco, and ongoing concerns related to staff and patient safety. It is critically important to also understand that at this time, while we were dealing with CMS, we absolutely agreed with their findings. We were accepting responsibility and working with CMS to address their findings and their concerns. Based on the recommendations by CMS to establish a distinct part unit, which would essentially take the 2 forensic units out from under CMS certification and oversight and separate it from the distinct part unit, the remaining 2 units, which would be certified by CMS. Riverview submitted a plan of correction proposing the establishment of a distinct part unit. This plan of correction was approved by CMS on August 29, 2013. And again, I would tell you that I know I shared this at the time. We were on national calls with CMS where they were acknowledging significant challenges around the country and similar areas of concern by other hospitals. As part of the package you're going to receive today, there was an op-ed in the New York Times about some of the challenges in New York, as well as a NPR story on California psychiatric hospitals and a major restructuring that recently occurred there related to their forensic populations. At the same time, Riverview was continuing to work with CMS to address the identified deficiencies. As you'll recall, LD 1515 was being debated during a special session of the legislature in August 2013. And I provided testimony to this committee in support of that legislation on August 22nd, 2013. The bill, as introduced, proposed to create a unit at the state prison specifically designed to treat the most aggressive and dangerous forensic patients. The legislation included the ability to transfer any of the forensic patients based on clear behavioral criteria. We shared with the legislature at that time that the issues in Maine were not unique to Maine. Many states are grappling with and continue to grapple with increasing numbers of forensic patients and increasing violence. Court Master Dan Wathen testified about the challenges that Riverview has and continues to have in fulfilling both its role in meeting the needs of civil patients and forensic patients. In fact, similar statements had been made by CMS national staff. During that testimony in August of 2013, I made it clear that LD 1515 was one part of the solution in addressing both the recertification issue and in moving Riverview toward becoming a center of excellence. Additionally, the legislature was informed of the amount of federal funding that remained at risk should Riverview's certification be terminated. Unfortunately, the final legislation adopted by the legislature expressly excluded individuals deemed incompetent to stand trial and those determined not criminally responsible by the courts. Neither of those populations were eligible to be transferred to the Maine State Prison. In September of 2013, CMS conducted a follow-up survey to evaluate Riverview against the regulations pertaining to a distinct part psychiatric hospital. This was clearly not part of the recent surveys in May and June, as RPC was not organized as a distinct part unit. So this was a new set of regulations against which Riverview was being evaluated. This federal survey team in September of 2013 determined that Riverview was not operating as a distinct part, and despite the initial findings involving safety of patients and staff being addressed, we had addressed all of those concerns, CMS moved forward to decertify Riverview with an effective date of September 2nd of 2013. Do you want me to pause while these are being distributed?
Now, Nick, the clerk has a vote.
Yes. I will tell you what page I'm on, but mine is in larger print, so you can with the glasses. Page 3, Jason, page 3.
Please.
So we disagreed with CMS's application.
Excuse me?
Yes. Sorry.
Is she going to, is the commissioner going to read the entire 8 pages to
Yes,
us?
I am.
History lesson.
I just wonder if it's an appropriate use of our time to be read to 8 pages of testimony. I mean, we can all read, and I believe there's questions also.
Well, I was asked to come provide an update, and I'm providing an update.
Yes, and I know that we had submitted questions also, so I'm just
If you'd like,
budgeting the time. I just wanted to know if the answer to my question is yes, she will be reading 8 pages of testimony. Okay.
The background is important to
we disagreed with CMS's application of the distinct part federal regulations and appealed this decision. I have provided copies of several of the legal documents that have been submitted by the AG's office on our behalf over the last 24 months. We did not disagree with their earlier findings, which is why the state did not submit an appeal, and which is why we continue to submit plans of correction to address those concerns. At the core of the state's appeal has been that CMS wrongly interpreted the federal regulations regarding distinct part units. At the core of CMS's legal arguments during legal proceedings over the last 18 months is that Riverview should have appealed the findings from May and June and submitted that appeal prior to September 2nd, 2013. Again, we did not disagree with those findings. As stated in our legal appeal, when CMS subsequently determined, wrongly, that Riverview failed to implement properly the plan of correction, that was an entirely new determination, having nothing to do with whether CMS should reopen its June 4th determination that the March and May survey findings warranted determination. To date, all of the legal proceedings have been focused on a procedural matter. Did Riverview file an appeal in a timely manner, or is the September plan correction decision a separate decision eligible for an appeal? It is and would have been difficult to appeal something in August that hasn't happened yet and won't be known until the following month. Again, Riverview was taking responsibility for the concerns and deficiencies identified and seeking to work with CMS to address. The establishment of the distinct part was a significant restructuring of the hospital and subject to a different section of federal regulation. As such, we continue to believe it should be subject to a separate appeal and review. Of course, while the state continued to appeal the decertification decision, we were also working on an approach to becoming recertified. At the same time, the federal government had shut down and we were struggling to get timely assistance from CMS. Over the next several months in 2013, we began the process of resubmitting an application for certification, and we acted on feedback from national CMS to connect with the Wisconsin State Psychiatric Hospital in Mendota regarding their distinct part structure. When we connected with the Wisconsin hospital, they were quite surprised by CMS's interpretation of the distinct part regulations and stated that they were organized as Riverview had implemented the distinct part unit. We also retained an outside nursing consultant to review all aspects of quality and safety at RPC in preparation for the new certification process, as well as to advance our overarching goal of becoming a center of excellence. We were also at the same time working with the Department of Corrections on the establishment of the intensive mental health unit at Maine State Prison, which is primarily now serving the Department of Corrections, correctional population, some jail transfers, and individuals who have committed assaults at RPC who are found criminally responsible for that behavior. One of the most significant events which helped to reshape the way treatment is provided at Riverview was a change in leadership at the hospital in March of 2014. Harper, who served as a patient advocate with the Disability Rights Center, has led major efforts at reforming Riverview since his appointment as superintendent. In order to further facilitate a treatment-centered approach at Riverview, Superintendent Harper removed all correctional functions from patient units and from the interior of the hospital. Additionally, Riverview established an innovative staffing structure with new positions known as acuity specialists. These positions are structured to spend significant one-on-one time with patients and are trained in identifying patient triggers and in de-escalation techniques. Superintendent Harper also doubled the clinical capacity for psychological assessment and treatment of patients. For the first time, all patients receive neuropsychological testing at admissions to inform treatment and risk assessment evaluations prior to discharge. These efforts, along with many others, have contributed to the continued outstanding performance of Riverview as a treatment facility. In June of 2014, Riverview received full accreditation from the National Hospital Accrediting Body, the Joint Commission. At the same time, CMS returned to conduct a full survey of Riverview's new application for certification. As you recall, in June of 2013, Riverview was out of compliance on 8 CMS conditions of participation. As part of the new application for certification, CMS denied Riverview certification, finding the hospital out of compliance on only 1 condition. Riverview did not have any negative findings related to hospital quality or safety. The only issue pertained to a condition of participation unique to psychiatric hospitals and was identified by only the psychiatrist on the federal survey team, and it pertained to the documentation in the medical record. Had this been identified during a regular survey while Riverview had its certification, Riverview would have been given the opportunity to correct the treatment record and likely maintain its certification. Unfortunately, as part of an application process for certification, this was an all or nothing equation. It is critical to underscore, though, that Riverview did not have any negative findings related to quality or safety. The medical record treatment issue, however, again, largely relates to the forensic patient population and the ongoing challenges of documenting active inpatient hospital treatment for individuals who no longer require a hospital level of care, but are court-ordered to remain under the custody of DHHS and in a secure facility. Nevertheless, Riverview marshaled its resources to work diligently to review all of the medical records and to implement the necessary changes to our medical record documentation protocol. This was lengthy and extensive. This process also informed the legislative proposals that were presented to the legislature in 2015 regarding the forensic population. In August of 2014, the three-member Department of Appeals Board with CMS upheld the administrative law judge's dismissal of Riverview's appeal. We appealed this decision to the Federal District Court in October of 2014. While pursuing the legal remedies available, I also tasked my office to look at every option available to provide the proper care, treatment, and supervision to the forensic population. During this past session, we came before you and presented the plan through the budget to move 14 to 16 forensic patients that have been deemed safe to a secure treatment facility program, and helped to introduce a bill which requested funding to establish a behavioral assessment safety evaluation unit. The secure treatment facility program is an ideal solution for those deemed not criminally responsible that do not require a hospital level of care. I won't go into the details about the testimony and why we brought this before you, but again, it relates directly to some of the challenges that we've had with CMS. Removing those individuals also is expected that Riverview's civil capacity would increase as a result of this and other proposals for the forensic system, relieving pressure on the acute hospitals and emergency rooms throughout the state. Furthermore, in compliance with the consent decree, Riverview has continued implementation of its policy of least restricted care. We agree with CMS that these individuals do not require acute hospital level care and should be appropriately cared for in a less intensive care setting, but at the same time maintaining the appropriate level of security warranted by this patient population. I want to just highlight for you the situation that recently occurred in California. Again, it's similar to some of the challenges that we've experienced. In California, you have a copy of this article. The state struggled for years to properly manage their forensic patients. Not only was the treatment subpar, but just like Maine, staff were regularly assaulted by particularly dangerous patients. In 2011, one of the psychiatric technicians at the Napa State Hospital was murdered by a patient as she was walking between buildings at the hospital. This, along with statewide protests by workers that worked in an environment of fear, prompted the California State Legislature to act, creating the Department of State Hospitals to oversee all forensic psychiatric patients. The California State Legislature funds this department with largely state general funds and a small amount of county funding. You can see the amount and the number of people being served. Not only does the Department of State Hospitals oversee the state hospitals, they also oversee 3 psychiatric programs located on the grounds of the California Department of Corrections and Rehabilitation. Riverview also recently received full licensure with no conditions from the Division of Licensing and Regulatory Services, which uses the same standards as CMS. Riverview also received a 96.7% accountability composite score from the Joint Commission, which is the highest score in over 2 years. Recently, the Federal District Court issued its ruling that Maine lacked standing to appeal the decision by CMS to terminate Riverview's certification. Again, this was not a decision based on the merits of our case, but simply that we had failed to submit an appeal in August. We continue to believe that the Secretary of Health and Human Services has discretion as to whether to reopen a decision. We are still evaluating our legal options in terms of the decision. Judge Levy in his decision also appeared to be questioning whether the state might not have another option for revisiting its right of appeal. Throughout this process and at every juncture, the legislature has been informed through testimony of the risk to the federal dish funding for Riverview. In 2012, the legislature authorized funding to be set aside in the Budget Stabilization Fund pending any potential future federal audit related to the drawdown of disproportionate share funding for forensic patients when the legislature rejected the department's proposal to replace those DISH funds. Again, in 2014, the legislature authorized another set aside of funds within the budget stabilization funds relating to the ongoing risk of federal DISH funding attributable to the decertification. At this time, the state continues to draw federal DISH funding. While CMS has indicated that those funds will likely be disallowed, CMS has not issued a formal notice to recover those funds. It is likely that CMS is awaiting the conclusion of the legal process. Again, we have not made a final decision on the legal appeal. Should CMS commence with a Medicaid recovery of funds, it would reflect a cumulative total of $30 million through August. Should CMS initiate this process, CMS would send the state a formal disallowance letter and a right to reconsideration. This correspondence would contain all the pertinent data points, elements as mandated by the Code of Federal Regulations. What you have following are all the steps that the state could take and would take that is separate from the issue of licensing and certification. This is a separate part of CMS and pertains to Medicaid funding and is a separate appeal process related to the recovery of those funds. Since the state will request retention of the federal participation of funds during this lengthy exchange, it would be required to pay interest on those federal funds in dispute if an unfavorable decision is returned. Given the recent legal decision, I am requesting the Appropriations Committee, as the appropriators of state general funds, to provide the department with a decision on how you wish us to proceed regarding the ongoing use of federal funds. Should you determine that the future liability and risk is too great to continue to draw down these federal funds, we would request an appropriation of $10.5 million for the remainder of this fiscal year and $14 million for state fiscal year 17. I am proud of the dedicated staff at Riverview and the care and treatment they provide each and every day to our most vulnerable individuals with mental illness in this state. Riverview is a critical component of our state's mental health system. Our efforts to address these challenges have a profound impact on the functioning of all other aspects of the system. I appreciate the opportunity to address the committee. Thank you.
Certainly, get some questions.
Thank you very much for being here today. Thank you, Commissioner, for your interpretation of history of Riverview. There are some major points that have been left out, such as the fact that 5 times you've come to us for emergency funding, you've always provided it as a committee. The loss of certification is very, very significant. It's the only hospital in the state that doesn't have certification, and we certainly have been eager over the years, over the last 5 years, to work around certification. And, I'm just mindful of the fact that 5 years ago, we had a situation where we were certified. We had forensics patients in Riverview at the hospital. After 2 years, we lost certification and have spent the last 3 years trying to fix the problem. And what you last presented us with in the spring, shortly before we adjourned, was a bill that would create a multi-million-dollar facility to take care of forensic patients. And I guess my question at this point is, even if that were adopted, we would be looking at 2017. And we're looking at a situation that between now and then, if we in fact adopted your proposal, where we continue not to be certified. Not being certified is a very, very critical issue for all of us, for patients' safety, for worker safety. And I guess my question is, what is your plan between, for the coming years to make sure that we have a hospital that is meeting the most minimum standards, so that we can assure patient safety and worker safety at a hospital. What's to happen in the coming years, and how do we handle that fiscally?
Well, Representative Rotunda, you're right, we will continue to disagree about what has happened over the last several years. It is a partnership, I don't appropriate funds. You have received numerous plans applying back to 2012 to identify the concerns that were raised, concerns about drawing down federal funds for the forensic population, given recent federal audits in other states. This has been an ongoing issue and concern to Riverview. I obviously certainly recognize the importance and significance of certification. I've also indicated to you that from both the national accrediting body and the Joint Commission, from the state's licensing perspective, Riverview is performing at a level, providing high quality care and treatment to patients in a safe environment. The issue that remains is the challenge of how to handle forensic patients who no longer require a hospital level of care. When CMS returned on our reapplication, our new application to become recertified, as I've said before, they moved the goalposts and addressed the fact that we had a number of individuals who no longer needed hospital level care. Years prior to this issue and to the decertification, Riverview, prior to this administration, had decertified beds. For some reason, CMS had allowed for a different process than its requirement that we set up a distinct part unit, which was the instruction provided to us in the summer of 2013. The plan has been presented multiple times that is an array of initiatives. Yes, funding was provided to establish the intensive mental health unit at the Department of Corrections, but you eliminated from that legislative proposal the ability to transfer people who are deemed not criminally responsible or deemed incompetent to stand trial. That's the largest percentage of our forensic population. We provided to you last year two proposals. One, self-funded, that would have established a secure treatment facility for people deemed not criminally responsible who no longer require hospital level care. We believe that that funding and that initiative would make the difference in allowing us to move forward with CMS to get recertified. They're looking at the hospital, and they've got to be able to evaluate the hospital in terms of all of the patients there and whether or not they require a hospital level of care. The statute today, for those deemed not criminally responsible, Riverview, until they are granted court permission to be returned to the community, Riverview is the only option unless we establish funding and another facility for their treatment, as many other states have done. Jay, do you have anything more to add to that?
Good morning. Just to give you some idea of what those actual numbers look like today, we're talking about 1 unit of the 4 units at Riverview. It would be the transitional forensic unit. Those people there no longer, in most cases, need hospital level care, and they're waiting to be placed in a petition process before the court system, which occurs every other month. We're allowed a maximum of 10 places on the docket, and that includes also people that are in the community. So there's, at the most, we usually have about 4 folks going to the court every other month. They can ask for modified release with the support of state forensic services and our own treatment programs. We can then support them for them moving to the hospital, in the community. So you have 24 people on that unit. There are 4 people currently on that unit that, writing today, do need hospital level of care. There are 4 that will be moving forward in the next 2 court dockets looking for modified release where they're living in a secure group home situation or staff apartments. And that leaves us with 16. The commissioner does have the authority to place the 16 people into another facility, but as the discussion targets the fact that we do not have another facility. So we need a secure residential program that does not design itself around full hospital level care as CMS designed. It's just not available anywhere in the state. We have to bring one up from the ground up.
Thank you both. And again, I had, looks like 100 pages of print here. I guess, for me, the question I keep going back to is 5 years ago, we had a hospital that was certified that had forensic patients. Within 2 years, we lost that certification. What was happening in the management of Riverview during those 2 years where we lost within that period of time our certification?
So I appreciate the question. We repeatedly answered that question. Dan Watson was here before you, citing, as has Elizabeth Jones in her report indicated to you, that over that period of time, there has been an increase in the number of forensic clients. That's the data that I provided to you, and the increase in violence among some of those forensic clients. It has changed. The two articles that I provided to you, one from the New York Times, one from California, both talk about the increase in the number of forensic clients nationally and the level of violence. It is different. But I also just want to indicate, there was a period of time 5 years ago when a number of those beds were decertified for that very reason, that we were using those beds for forensic clients and we were not drawing down the dish for those individuals.
Senator Volunteer.
Thank you very much, Mr. Chair. Commissioner Mayhew, when were you first appointed to DHHS?
February 2011.
February 2011. And I guess reading through your testimony, going through the history, obviously in several different paragraphs you squarely place the blame for the problems at Riverview on the legislature, not on DHHS. Although
That's not true, Representative.
the legislature failed
What I'm
to
suggesting
do your
is
bills,
that
the
it is a much
legislature
more
failed.
comprehensive process, that we have taken a number of steps and accepted responsibility, but there are other elements of resolving this that do involve the legislature from a policy and a funding perspective.
And as was mentioned previously, 5 times DHHS has come to us on supplemental budgets and various supplements were granted. Our latest one I thought we were actually going to be getting a review today on the positions that we gave you in the supplemental budget, have we been hired and stuff, but I didn't realize we were going to be rehashing history. But since we are rehashing history instead of going forward.
The request was an update post the legal decision.
Okay, and my question, so, was on my sheet that was included in our appropriations package. I thought we were going to be going over today.
Sure that Superintendent Harper did.
That were posed to you. So I guess I have a question, and I do appreciate that you go back to 2012 on this, because you're talking about a supplemental budget in April of 2012. And this is when you talked about the issuance of dependence on federal funding was brought to the legislature's attention. And then secondly, the department requested to reduce overall dependency on federal DSH funding by $10 million and replacing it. So this goes back to 2012. So certainly no one can say that the department has not received funding or consideration due to politics, because obviously in 2012 it was a Republican governor, Republican House, and a Republican Senate, and they denied all of their requests. So this, people have been saying obstructionists here, that we have denied these requests. Obviously, these requests were all made when you had control of everything, and they were not granted. So I guess I take a little exception to everybody blaming the legislature, and rehashing old history. Why is it that you have been unsuccessful in getting any plans then through when, even when you were in control, when we were in control, or now under split control? Do you think there's a confidence or a credibility crisis, or what can we do? Are we at the juncture really that we need to get an independent agency to tell us what to do? Or to look at OPEGA, or having somebody come in? I mean, this, like you said, you brought it up. You started in 2012 in April. and the legislature did not do what you wanted to do. And that wasn't mine.
We have separate branches of government.
Yes, and that's what I'm saying. Do you
I'm
think
not
we're
talking about Republicans or Democrats. You continue to ask, what is the plan, what is the plan, what is the plan? I have answered, I have proposed, we have presented.
Right, and I'm looking
Parts
at going
of those
forward,
have
not
been-
just
But
rehashing.
going forward is dependent on actions that have been taken over the last 24 months. I cannot appropriate funds. Yes, funding has been provided for the staffing requests that we have made, and we've talked repeatedly. This is not only about addressing the issue of forensic clients within the hospital, but in pursuing a center of excellence, which is why Superintendent Harper has brought forward position requests to change the clinical composition of staff at the hospital. OPEGA has already and continues to be involved in its review of Riverview.
Are we going to be talking today about the supplemental budgets and the staffing and the crisis that we had on the floor for people getting hurt? Is that something that we're going to be talking about today?
The fact that our joint commission has given the hospital its highest score in 2 years is a strong statement about the quality and the safety in the environment at Riverview. The fact that the acuity specialists have been brought on and that you have supported funding for those acuity specialists has dramatically decreased the number of emergency psychs and the use of restraint and seclusion at the hospital. That is in the remarks that I just provided. Superintendent Harper can absolutely elaborate on that. The posting of positions and the hiring of positions, those have all been proceeding. We've been extremely pleased with the applications we've received and the number of individuals that we've been bringing on board.
And I know
And we get regular updates that are submitted to the Appropriations Committee as well on those positions and the number that have been hired pursuant to language that was included in the budget.
it's just that when we did the supplemental budget, we were in crisis mode. And it's just disconcerting that we still haven't filled those positions, all of those positions, when we were in a crisis mode back in April, and now it's September. And I know in April, then when we said, you said you couldn't hire anybody until we passed the biennial budget because nobody could apply, and then we had to wait until May until people graduated. Well, now it went through, June, July, August, we're in September. And again, my question would be is, what is taking so long to fill the rest of those positions, since we were in a crisis, and it was that we needed all of those positions. Every single position was critical.
Do you mind if I go back to your beginning of your first comment and then go right directly into that?
I think I'm done with my questions.
So I think the position that we find ourselves in, without drawing guns and laying blame at equals, basically the world around us has changed very significantly, has a dramatic impact on a relatively small state with one forensic psychiatric capacity, and that's at Riverview. What has happened is this: in the last 7 years, we would see at Riverview one NCR being brought into Riverview. Between 7 years ago and now, I will see every year between 3 and 7 NCRs brought to Riverview. 7 times the capacity that that building was built for to try to do. Not just bring them in and leave them there, but bring them in and move them to the system as they're being treated. What has happened is the lawyers are much more adept at using evaluation review procedures to look at whether people are competent to stand trial, and all those people get backlogged up and waiting for a bed at our facility. People that are then found competent to stand trial move forward and with legal advice, and many times great legal advice, they're able to use a not criminally responsible defense, and they end up at Riverview. So we have 7 times the amount of pressure placed on one single facility, and in no way to bring the pressure off, because there's no other alternative for us. I believe that the legislature is the place that the solutions get created, with the guidance of Riverview and the department relative to the types of programs that should be reviewed. The pressure does not come from the legislature on Riverview or between the executive branch on the legislature to get this done. It's been created around us in our society. And nevertheless, here we are. The bottom line is We have too many people in Riverview that do not belong in Riverview. And technically, under the terms of the consent decree, where we're supposed to provide the least restrictive environment relative to their individualized treatment needs, we should be being forced to look for a different facility and program. But Riverview is the only game in town, so that's where they are. We work diligently with both the court master and the advocates to move people just as quickly as we can through the system. So we came to you and asked for a number of positions because we were in a crisis. A crisis created by that increased pressure and capacity. The individuals that are coming in at 7 times the rate they used to come in are also probably 50 to 100% more prone towards violent behaviors than we had ever seen before. We are a hospital. We are oriented towards an open milieu psychiatric treatment program. What we end up with is basically a 1 foot on the hospital side and 1 foot from people coming directly from jails in order to have those evaluations about whether they do need psychiatric needs. Nevertheless, their jail and criminal behaviors come with them. They all get mixed in together, and that crisis created where we had staff being worked very regularly, patients being neglected with active treatment because of the staffing numbers. We came with an emergency request, and I thank you very much for all the money for every position we asked for. I'm very, very sorry for the delay that occurred in getting it started, because that was critical. We told you at the time that we needed to have the positions of recruitment and retention specialists out front to get to the nursing schools, the social work schools, the mental health programs around the state in order to recruit. 30 days missing that target was critical for us. We've been in a catch-up mode since then. We are behind the 8 ball, and we're pressing as hard as we can, looking for fall graduation and midterm graduation and winners to try to pick up. I will tell you this, the only question that I never ask, over and over again, from every nursing cadre that comes through, which is usually 40 to 50 nurses, depending on which school comes through, is, will you still have the funding available in 3 months? We hear all this stuff about it being unsafe, and they don't see that. But the part that they take care of is, if I come to work for you, am I going to have a job? So I think it's important we just continue the way we're going, as hard as it is, recognizing that we still have a level of violence that is not the level that we are in any way interested in at all, either patients or staff. That we have a deficiency in the number of applicants available for us and for Maine General and for TOGAS and every other medical facility we check within the hospital. We're not unique in that. And that we just kind of get this done. But the part that is absolutely missing here, that gives us no ability to escape that, and I recognize it will take more than a year to bring it online, is basically look at the places where we take that pressure off of Riverview on the forensic side and look at the beds we need for a residential treatment program. There's no other option. CMS has made it very clear, when you put somebody in a hospital that does not need hospital care, we're not going to pay the bill. There's nothing magical in here. There's nothing smoke and mirrors in their regulations. The world changed around us. They've applied the regulations as conservatively as they can because they're acting as an insurance company. And our only way out is to find a specific program that recognizes that, doesn't fight it, and gets the relief that we need. So we are, Senator Valentino, running at about a 19% vacancy rate at Riverview. We, on average, leading up to the last 7 years, would be between 14 and 15%. So even with the position you gave us, even with our best effort, we're still behind. Ideally, where I would like to get at Riverview is that I'm now looking at a vacancy rate higher than 10 to 12%. That requires us to develop an infrastructure that we've never had available before. And until we go back, and by the way, I made a change of hiring. When the positions came late, we moved everything that was direct hire to the front of the line and took all the management positions and people that we hope would help us recruit and retain people to the back of the line. So now we're at the place where we're doing recruitment and retention places to look forward to reorganizing the training the right way for the next graduation class that comes through. I think then we will start to actually very close to closing that gap. I'm not going to deny to you that it's not where we want. I'm not going to deny to you that in fact there are people that are hooked there too often, both patients and staff. I can tell you this though, the quality of the clinical care provided at Riverview has never been as high as it is right now. We're virtually 0.4 of a point from probably the highest score that you can get in a hospital from the joint when they look at us. The quality is there. You should be proud of that. I'm proud of it. I'm proud of the staff that go every day to work to do that, even with the crisis around them in terms of some violent patients. those people need to be brought into our situation or removed one way or the other. That's kind of your decision about what we're going to do here. But it's not something anybody designed. It's the fact that the world changed around us very quickly in about the last decade. So you design a building for 10 years, you find you built it 10 years ago, the world moved forward in 10 years and it's changed the way it wants to do things. I do not deny any of these lawyers the right to have someone come in and reevaluate. They should be. And we need to decide who needs the critical care in a hospital that they do need. And the ones that don't, we need to find that alternative.
That's right.
Thank you, Mr. Chairman. Thank you, Commissioners. Harper. I guess I had a little question about the Wisconsin case that you mentioned here, that CMS actually directed us and just to look at Wisconsin's psychiatric hospital, and then that Wisconsin was surprised at the kickback that we were getting from CMS. And I had I'd like to follow up on that, and also to understand if they have a there. I know that some of the other states have a separate facility-based unit type setup, I guess, and I just wonder how many other states, and is Wisconsin one of those states?
So we have been looking nationally, and as I mentioned, there's been a lot of changes. California's recent change in terms of their structure. So trying to get a current picture on a state-by-state basis. There's obviously different approaches that have been taken. New York has had some different approaches as well. I need to take a look at whether Wisconsin has, I believe they do have a secure treatment facility that is less than a hospital level of care. When we spoke with that state psychiatric hospital in Wisconsin, they were surprised at the requirement by CMS to have 2 separate staffs between the distinct part unit and the non-distinct part unit. And frankly, as is the case, I think, with some regulated entities, they were a little concerned about the spotlight being turned back on them simply by engaging with the state of Maine in terms of how we needed to organize a distinct part unit. The reason why the other hospitals and how they are or have retained their certification, why it's of interest, is to the extent that we're able to demonstrate inequitable treatment in the interpretation of CMS federal regulations from one region of the country to the next.
Thank you, Madam Chair. Thank you, Mr. Harper. Thank you, Commissioner, for being here. First of all, I have just a statement or an observation, and then I have a question, some specific questions about where we're going forward. My observation is this: page after page of history and timelines, assessing blame to various entities for where we are now, from the feds to the shutdown to the legislature. The responsibility for operating and administering the state's hospital for the mentally ill lies with the Department of Health and Human Services and the administration, not the legislature. Not one legislature.
And I didn't say that.
And secondly, people's concerns when they apply for a job with the department are not about, is the legislature going to appropriate? But they're questioning whether or not the federal funds are going to be there, whether or not the hospital is going to be a certified hospital, and whether its future is tenable. Those are the things that people who apply for jobs are worried about. But those observations aside, if you as an administration are asking us to make a severe departure from the way we treat and care for our mentally ill patients, to go to a privatized, separate type of system, we need adequate details on why and how and under what standards that hospital or that facility will be operated. I quote the Press Herald editorial that states, quote, "But far more details on the plan are needed from the LePage administration, which has yet to show that a privately operated facility will be held to the clear standards of care and high level of accountability that are necessary, end quote. I believe, Mr. Harper, that you care deeply about the patients and staff of your hospital. I have toured that facility with you. When you come before us and you speak about the patients and the challenges that they face. You speak about the professionalism of your staff, and I'm deeply impressed by that. My concern about details is nothing to do with your credibility or your professionalism, but you are asking us to take a step forward into a completely new way of treatment. And as legislators who have to appropriate the funds, we must have adequate details, not page after page of history as to why we got where we are. That's what I'm asking. When are we going to see the details about a plan, not a 14-page piece of paper at the end of the session?
Representative, I was asked to come in here and provide an update. I am repeatedly asked, what's the plan, and the revisionist history exists on both sides. I came before you to provide information that is a 24-month history of what has occurred at Riverview. It is important to connect the dots from the various pieces of policy that's been brought before the legislature, the discussions that we've had. The ownership of the management of the hospital is squarely on the department's side of the equation. We take that seriously and we take it with responsibility. But the change in direction and the oversight of the hospital related to CMS's concerns and the increasing number of forensic clients at the hospital requires engagement with the legislature. And it is imperative that we don't lose sight of the various discussions that have occurred over the last 24 months with the legislature. I came here to provide information. I am not going to sit here and listen to an attack or be questioned about the executive branch's role. I provided information. To the extent that there are more questions that you need asked, we will provide those in writing. But I will not sit here and listen to attacks.
My question stands. As was stated in the Press Herald article, editorial, when will we receive specific details about where we're going forward?
It's an editorial. You were provided information, you were provided testimony, you were provided details of both of those proposals. One of the proposals that was in the change package was just summarily dismissed. Happy to respond. There needs to be an opportunity to actually engage constructively, as we are prepared at all times to do with the legislature and to get into the details of the policy discussion. We are more than willing to do that. It's part of the overall plan that needs to be part of the equation in addressing these challenges with Riverview.
I'm wondering if we could have a better understanding of how different states do approach this problem, since it seems to be something happening across the country. So we were brought at the very end, within the last few days, the plan about the base program and the amount of money that that would cost. I have a hard time understanding that we have Riverview left with 39 patients and a 92-bed capacity. What happens with that facility? And these are just some of the stuff going through my head, but my real question is, can we find out how different states are handling it? How many states have everything within one facility, and how do they make that work with CMS? How many states don't do that, and if they don't have it all in one facility, how do they use their different facilities to treat patients?
So we have made requests looking at a couple of different national associations to get a state-by-state picture of each of those states and how they handle their forensic population, both in terms of how they use secure treatment facilities along with who they may be serving in the hospital. Some of them have completely freestanding forensic hospitals. Some continue to have several units within the hospital, some treating civil, some treating forensic. So we're trying to get characterization of that, but also to look at how some states have recently reflected on their model and have made changes. But we should be able to have greater research on that as we look nationally at what each state is doing.
I'm sorry, did you have something else? Representative.
Thank you, good afternoon. Just want to follow up on a couple of points that we made in the presentation. On the idea of replacing the DISH funding with general fund, I sort of understand, I wasn't here in 2012, but I understand that that was proposed, and then it sort of looks like maybe that's part of what the department's asking in the closing about, if we do pursue DISH funding, making sure that money is appropriated to replace it in case something doesn't work out with CMS. If, let's say that the legislature does say, okay, we're going to go with what happened, which was requested 2012, just put general fund money in to replace DISH funding. It's two questions from that. One, does that mean that we don't need to have CMS certification anymore for Riverview at all? Or is it still needed, but for something different?
Yeah, let me just, so CMS Medicaid is certainly making the assertion that the availability of the federal DISH funds is directly linked to the hospital retaining certification. That could be debated in terms of what the intent was when Congress set up disproportionate share hospital funding and created as part of that, it's known as DISH, IMD, Institutions for Mental Disease. So they separated within the disproportionate share hospital funding that was provided to each state. They then created a cap amount that could be used for institutions for mental disease. IMDs are absolutely ineligible for Medicaid funding. The federal government has long asserted the view that treatment and providing for the mentally ill is a state responsibility. So Spring Harbor, Acadia, Dorothea Dix, Riverview, they're not eligible to bill Medicaid. Disproportionate share funding is a Medicaid fund specifically to address the uncompensated care, the Medicaid eligible individuals through this DISH IMD funding formula. There could be an argument made as to whether or not the DISH IMD is in fact directly linked to CMS certification. That would be potentially a separate set of arguments to be made. But barring prevailing on that, or regardless of whether or not we prevail on that, at this time, CMS is asserting, Medicaid is asserting that it is directly linked to certification, which is why the appeal was so important, was to preserve our right to those DISH funds and to continue to argue against the decertification. Separate from the DISH federal funds, CMS certification would potentially, the lack of it, although I know that Superintendent Harper has done an excellent job recruiting clinicians to the hospital, but it would be the appearance or the concern by those looking at Riverview for employment as to whether or not, now again, we've got Joint Commission accreditation, and there are likely hospitals, as I've looked across the country, that are not certified by CMS, but do retain Joint Commission accreditation. And part of the issue, it relates to the forensic population and the conditions of participation within Medicare. So if you could secure funds and not be dependent on the federal funds, there would be a larger issue about how important then is CMS certification in recruiting your clinical staff to Riverview. Jay, do you want to add anything to that?
I appreciate that clarification. So if the legislature was to make a decision to replace, sort of, for funding purposes, provide general fund dollars that sort of allow use of general fund versus DISH funding to pay for those patients, would we still need to have the base facility, the group homes, so I'm just thinking about funding here, so we have, like, say, 10, 15 to replace DISH, and then there'd also be these separate requests that are gonna cost some money. So are they sort of, do we need both, or is it still one?
Yeah, let me address. So in terms of the federal dish funds, and if you were to provide 100% state general fund dollars to the hospital and no longer pursue CMS certification, you could potentially forego the establishment of a secure treatment facility. It does not address any concern about having added civil capacity. So to the extent as we continue to struggle with hospitals being able to timely admit individuals to Riverview or to Dorothea Dix, when Riverview gets backlogged with the inability to admit civil patients, obviously it has a ripple effect throughout the system. So separate and apart from CMS certification and the availability of 100% general funds would be the system's capacity to appropriately meet the needs of civil patients. The base unit actually gets at what I think the county jails continue to be challenged by, and that is the timely access to services for individuals who need to be evaluated, need to be stabilized in an inpatient setting, or those deemed incompetent to stand trial, who under the law, the change that was adopted in LD 1515 did provide added flexibility to the department in terms of where we could provide restoration services to people deemed incompetent to stand trial. But that still requires, if it's outside of Riverview, establishing what that facility could look like, what is in the best interest of providing restorative services. What does that environment need to look like? And that's where the base unit in an ideal system would allow for that immediate evaluation and determination of what is the right and best environment to receive treatment and care for those individuals. And I know Jay can elaborate a little bit more on the base unit.
Well, I think what you need to do is understand history, that the capacity for the upper cycle is basically just, that's basically complying with CMS saying that you want to get money from us, you have to only people in the hospital who care. So people that we know don't, that we agree with them don't, they would need to move out. So if you general funded all those beds, you wouldn't have the discussion with CMS at all. The issue of the base unit is really the issue about safety and security relative to the staff and the clients who are already there. Here's the classic discussion I have on a relatively regular basis. A county commissioner will call me, the county manager will call me, the head of the jail will call me in county and say, we have a person in our cell that looks to us like he has a psychiatric crisis, and we need to get him to your facility because we can't handle it. And I say to them, so we get this straight. You have him in a jail with jail-trained staff. You can't handle him. You want to move him to an open milieu hospital where they're going to take a bed next to your grandmother? And then there's usually a pause because they recognize the irony of going from the most secure to one of the least secure by design type of programs with the person you're saying needs maximum security. And then they say, yeah, I need to do that. There is a sense that we have some magic that we can do with people that are behaviorally out of control, which in fact we are prohibited from doing because we are a hospital. So that program does need to be separate. It has nothing to do with gaining or the use of the general fund money relative to CMS.
I'm sorry, I had you up to your last point. Okay. I guess I thought that was the situation you just talked about with county jails, and that's very clearly what the Maine State Prison Unit was for. I mean, those aren't a protected class of people that there's some concerns with it. So why wouldn't they be able to go to the
So to go to the Maine State Prison, which by the way suffers from the same dynamics that we do relative to staff availability. So their bed capacity went from 30 or 20, whatever it is, down to about half of what their capacity is. People that are already in the jails that could go there, that they're thinking of sending to us, we're able to divert them only if we can demonstrate a history of documented violence. We can't take someone that gets in our door who starts to be violent and move them back out to the prison. It's got to be right at the front end. We get one shot only for abortion. And the law also says we cannot give opinion on cigars at all.
And just actually another kind of word question, actually going into the ISTs and the CRs. So first of all, thank you for recognizing that defense attorneys are doing a good job, that they're not just sending people there because they don't want to deal with clients. Because there is due process, and there are some very serious constitutional issues, as I'm sure you know, around whether or not someone's competent to engage in a trial that might presumably be for a long period of time. So, I don't know if I've asked this before, and I'm sorry if I haven't, it may be in some materials. This sounds like a really great conversation to be having with the judiciary and the prosecutors and the defense attorneys around the appropriateness. And I had a really great, Lenny's Enterprise was a really great conversation with Dr. Amy Block, who, as I understand, is the head of the State Forensic Service. And she talked about how there are some efforts going on to sort of educate different populations. When we look at Title 15, which is where the examinations can be asked for, of course, before the evaluations be done, defense attorneys can ask, and prosecutors can ask. So I just had a case where I objected to the evaluation. The prosecutor wanted the evaluation. The court ordered the evaluation, or objected. So I mean, it's not just defense attorneys that are contributing to this. I don't know the numbers. I just gave you one anecdote. So that there was actually a Benjamin news article about another case where the defense was objecting to it. So have there been some either a cultivation or ongoing conversation with the Chief Justice or with the court chiefs about, you know, if somebody's picked up for a shoplifting, sure it might be a felony because it's the third time, but you know, if you have competency issues or if you have, you know, they were hearing voices at the time that they took the patent gun that led it to being a felony. You know, maybe you could do some alternative for the judicial system so they never have to come through. Are those conversations happening to try to release pressure?
They are, and it's kind of slow going, unfortunately. The court has just been very helpful for us to kind of orchestrate and figure out exactly what we need to be sending to judges so that they will hear it. And there has been discussions, and as you know, as you went through training, and a lot greater will be those who meets with the defense attorneys and I think prosecutors also from the DA's offices to talk about what the system actually does and what it can do and how it's used. I think we're all in agreement across the board that everybody should be entitled to full constitutional rights to the judicial process, and part of that is a role that we need to play relative to the question of competency. The question we're realizing in real life time, though, is performing that role inside a hospital does not really work well for anybody. It actually gives a false set of incentives for the patient who is coming in to behave in a certain manner in order to basically game the system, to be either be competent because I want my attorney's got a good deal for me, I want to be competent to get back in front of the judge and close the deal, or be incompetent because it doesn't look like this is going to look really good for me and try to do that. What we need to do is isolate those folks so we can really watch and pay attention to those behaviors and document them, along with state forensic services the way you and the defense and the prosecution and the judge to making the best decision. So right now we're kind of caught in it. We've been trying to have these discussions. We have more and more discussions every year. A year ago, our clinical director actually went to one of the meetings with the defense attorneys to talk about this. But you're absolutely right. That's one of the roads we do need to proceed very vigorously if we can do that.
Representative, I would just also add that we are looking at the way in which we triage individuals deemed incompetent to stand trial, to actually look at the offense, to look at their time in jail, and to figure out how we can structure their access to that restoration process. And again, Dr. Blanc has raised with me, and I'm sure perhaps in her conversations with you, how important that environment is within which the individual is residing while those restorative services are occurring. So we're continuing to look at other options. We know of programs nationally that have been designed actually in the county jail where those restoration services are provided. We continue to evaluate what options that might provide to the state to to more timely address the demand.
And on the other side, I also, I can't remember if it was with Dr. Locke or just conversations that happened. On the other side of the court process, where, once the court orders the department to be a custodian for somebody until they're either restored or until they're not a danger to society, that there's some pressure on that end as well, where courts are very reluctant, I don't know if this is true, but very reluctant to give permission for the department to sort of stop a certain level of responsibility of a person, whether it be, look, we're not going to grant the privileges that allow the person to live out and then have some intensive outpatient to really that does affect a lot of, when I need it, I can't think of what the program is. But basically, thank you, yes, I can call back in. I understand that maybe there's some pressure on that side too, but once they're in, I was like Hotel California. So is there,
Well, I
they
think,
never leave, right?
I think it gets to what Superintendent Harper was saying, and that is that there is a view of that Riverview is the place to send these individuals in order to minimize the risk elsewhere. And that then is no longer simply looking at Riverview through the lens of what a hospital needs to be doing. That is a risk-adverse response that is seeing Riverview as an answer to a multitude of concerns that really creates a pressure on that environment to deal with a host of issues that go beyond some of the ones that we've raised in terms of physically violent individuals. People who've had a traumatic brain injury. We've had a number of individuals who are committed to Riverview, sent to Riverview. That is not a place that can provide the kinds of services and supports for someone with a traumatic brain injury. Individuals with an intellectual disability, that Riverview is not where they should be placed in order to more effectively get their needs met. But it's just a number of examples where lacking another option, Riverview becomes, unfortunately, the answer, and it really creates this conflict between functioning as a hospital and addressing these other needs. Jake, you might add to that?
Just to give you an idea of what the patient population looks like, when we're dealing with individuals, we can't nicely put them in diagnostic categories. On the forensic side, 30 to 50% of the individuals we're dealing with have been deemed not criminally responsible or also suffering from traumatic brain injury type of we're worried about comprehensibility the person can really bring to understanding both the rules and regulations and what they're doing. 65% of the patient population across the board has a significant long-term trauma event that is affecting their behaviors and their decisions. 85% of people are usually involved as part of their normal, unfortunately we call it normal because it's the progression of this treatment of basically treating themselves with substances, a substance abuse. We're a hospital. We treat our soft spot, we're right in the safe zone, so when we're working with in a hospital around looking at psychiatric conditions. When we're talking about neuro type of therapy for people with head injury, developmental disabilities, we're not structured for it, we're not staffed adequately for it, we're not the right program for it. We're talking about people that have long-term heavy substance abuse issues that they need to detox and disengage, and we're a whole different way of looking at trigger mechanisms, risk triggers and stuff like that. We're not able to do that very effectively either. So we have all that mixed into the population. So you're right. It is pretty significant. Once they get in, they're required to be under the commissioner. You don't have a lot of choices to get them out without going back in front of a judge and convince them that the behavior that they saw going in has somehow significantly changed to have them say that it's okay to leave. Because if the behavior was driven by traumatic brain injury, it's still there. If it was driven by developmental delays and stuff, the person has an IQ of 40 or below, it's still there. Those are part of the person's characterizations that we have to use to diagnosed them. So many judges look at that and say, especially if you're back in front of the same judge, say, kind of looks like the same person I sent you. I'm not really sure you're really convincing me to say, let's move on. We don't have halfway houses in the state. We don't have programs that allow us to have one foot in either condition. That's closer to the model of the not needing hospital care but still needing secure treatment programs that we'd like to get to.
Thank you very much.
Representative Timberlake, our shrinking violin over there, who's been sitting there as a patient.
Thank you very much. I've sat here and I've listened and I've read all the acronyms again. I don't know what acronyms stand for, nor do I pretend to stand for it. I'm not looking for an I got you moment or any of those things. I think Representative Sanborn asked a very good question, what our plan was, how we get to it. Every day in our organization, my father or my brother or one of them come to me and say, I need this fixed or that fixed. And I say, well, let me go get my wand and I'll wave it, and before the end of the day, I'll get it fixed for you. So I guess what I'm getting at is, I'm going to charge my wand up and hand it to you, and I want you to tell me what the solution is to this problem, other than the fact that if we lose the court case, we're going to lose $20-some million, and we move forward. I'm a man that doesn't pretend to know everything about this and everybody that you're working on there, but I'm a man who looks to find solutions to a problem. And I'm looking for what the solution is and how we help you, the administration, and everybody else that are around here, how we fix this problem. And we've stopped the bleeding of you coming back and asking us for money every so much. We've done a lot to do with that. But I'm looking for you to charge the wand and tell me what do we need to do in the future to get us back so we can collect that Medicaid money? What has to happen? Because we need to move from here. We can continue around the circle and have the same circle of talks and be back here a year from now having the exact same conversation. I need to know what it is we have to do, whether we have to bite the bullet and do something different, where it is we got to go. I still have listened to this for an hour now, and I don't know what I'm supposed to do or where I'm supposed to be. And probably I'm the only one sitting around this table that doesn't know that. But that's the question that I get for you, Commissioner, is here's the wand, tell me how you fix it and how we move forward. If I lose the $20 million, I lose the $20 million. Okay? How do I fix it? That's my question.
Today, Riverview draws down $14 million a year in federal disproportionate share funding. So the discussion that we were having with Representative Fry about the nature of CMS certification. If you choose to not pursue CMS certification and provide the $14 million in general fund, that would resolve the problem. If you believe that CMS certification remains important, then we have to comply with their terms. Their terms now, we've addressed the quality and the safety. Their terms now are that you cannot have a number of individuals at that hospital who don't require hospital level care. We provided a proposal in the change package last spring that self-funded the creation of a secure treatment facility. That would house between 14 and 16 individuals that today are at Riverview that do not require a hospital level of care. Those are the two choices. The base unit would be great in an ideal model to better facilitate more timely access to that evaluation and those services and to keep some of those individuals out of the hospital prior to being behaviorally assessed. But the 14 to 16 individuals that are within the hospital today that do not require a hospital level of care, that creation of a secure treatment facility is roughly a little more than, I know somebody behind me is going to correct me, a little more than $3.5 million a year. 3.8.
So, is the question, as I understand it, if I was making a decision, whether we want to continue to receive $14 million a year or not? And is the question I ask back to you then, if that's the way I understand it, is it costing me more than $14 million a year to receive the $14 million a year? Because if it is, I'm willing to give up the $14 million a year. Or do I need to create another facility that's going to cost me less, I'm going to generate break even, whatever it is I got to do? I'm talking as business here, so that I get the patients taken care of, and I stop the bleeding, and I stop having to go through this every 6 months. What is it that I need to do? What is the best avenue out of this problem?
The issue, Representative, is if you had entirely a civil patient population at the hospital, the concern about drawing down federal dish funds would be far less. It is the inclusion of the forensic population that has long been a concern, both in terms of the, in fact, eligibility to draw down federal dish funds for a population that is committed to the hospital through the courts, and whether that is at some point subject to an audit by the federal government, or whether or not those, if you remove those individuals and fund them separately, what is the civil capacity that could be better addressed for the hospitals? The Health and Human Services Committee certainly dealt with this issue, hearing from a number of hospitals about the concerns of people who can't get timely admitted to an inpatient psychiatric bed. So if you had only civil patients in the hospital, we likely would not be having this conversation about the availability and use of dish funds. It does, however, require the commitment of other state dollars in order to address the forensic population. But you're going to fill those beds at the hospital even once you move those forensic clients out.
So as I understand it, the forensic patients are technically what's costing us our accreditation, or however you want to call it. That being said, and I remember a year ago, seems like it was forever now, and we sat here and had a conversation about building a facility, a rental facility, and moving a facility to somewhere that was going to move these forensic patients out of there, and that would have solved that accreditation problem there. But what would it have created us for another problem when we did that, other than the cost, and what was the estimated cost of doing that?
That was the $3.8 million that was in the change package, would have created a secure treatment facility.
Would that have fully funded the treatment facility, or would that just created it, would that would have been?
That would have fully funded.
That would have set it up, got us going for $3.8 million, and we wouldn't be fighting over $14 million.
Correct.
Okay.
Thank you. And just to build on that, Representative Maloney, I think that's what Representative Grant was trying to get at, that we were looking for the details about that proposal. And there were details that were not missing, that were missing, and as appropriators, it's our job to make sure that taxpayer dollars are being spent wisely, and then we know how they're being spent, which is why we were concerned that there were not more details around that proposal that came to us about the hospital experience and such and such.
And Commissioner, that was 3.7, 3.8 per year, okay?
Right.
Yes.
And I know the Commissioner appreciates the fact that that's our job as appropriators, is to make sure that we have those details so that we can make good decisions on behalf of the people of Maine, taxpayers, and that's our job. I know you appreciate that. That's not that our questions to you are coming from that spirit of trying to do our work and
I just
give you a hard time.
Yeah, I just would prefer those questions to be referred during the legislative session when we could have responded to them. I think it was quickly taken out of the change package.
And Representative Furtado, Madam Chair, I really respect that. In that, and I'm coming from the same boat. I'm looking to stop the discussion on this, and not because I don't think it's anybody's got anything that's not warranted, but how do I fix it? You know, I'm a fix-it type person. That's what I do every day in my life. And how do I fix it? And it looks like we fix it by either moving those folks out and spending $3.8 million a year, and then we can continue along, and the world will be a wonderful place, or we continue to fight the battle we fight, and we sit around the circle and have this discussion 6 months from now and say, why isn't it been fixed? And I think from that point on, it becomes our problem not their problem because we didn't fix it.
No, it's not my counterpoint, it's just, if you hear the frustration, Representative Timberlake, for those of us who have been on the committee for a while, it's because for the past 3 years, we have been trying to work with the administration to fix it, and TAP is providing money that they needed every time they come to us saying, this is what we need now. And so, this is the latest proposal, we need to understand it, and we actually, we've been working for 3 years now to fix this and to provide the funding that is needed. So I understand what you're saying. We're all trying to fix this problem. We all want to move forward. We also want to understand the details of the plan, and we're trying to get the details of the plan.
Representative Jorgensen?
Thank you. I actually, a lot of the questions I had have been answered by actually Representative Timberlake's question. But I was looking at the issue of the, I'm thinking about all the things you're balancing here. I mean, you're dealing with patient safety, staff safety, the whole picture of mental health care in Maine, the forensic patients, what the makeup of everybody in the institution is. And I'm looking at the example you provided about California. And it says that it's $1.6 billion for 6,953 patients, which I think, my calculator, a lot of zeros there, but that comes out to about $241,000, $766 per patient per year. And I guess my question is, what is the per patient per year cost in Maine? Do we have that? I'm sure you know that. I obviously realize the cases are very varied, but if you took the total cost outlay, divided it by the total number of patients, what do we come up with, and how does that compare to California?
Well, it's always difficult to do an apples-to-apples comparison because they've got different levels of care that they're supporting through that model in California. Just in the hospital setting at Riverview, it's $1,200 a day for hospital level of care, and to meet all of the licensing, Joint Commission, and CMS requirements. To be in a secure treatment facility would be closer to $600 a day. And you are right that all of this is part of a larger continuum of services, from peer services, the crisis system, the community mental health agencies, the ACT teams, the inpatient psych units in the community hospitals, Harper, Acadia. It's all part of a system that we are constantly looking at and evaluating in terms of its functionality. Is every aspect of that system fulfilling its respective role? And the challenge, of course, is when any part of it isn't meeting its highest level of its full service, it affects the functionality of the entire system. The crisis system we have been working on and trying to really restructure that to more effectively meet people to where they need their services, to reduce the number of people going to the emergency department. Once you get to that emergency department, there is a tendency to admit. And if we could do a better job with the crisis observation beds, crisis stabilization beds, all of those are aspects that will help to address the pressure on the system. And certainly Riverview is a pivotal part of how that system functions.
And just to confirm here, the $3.8 million is it's a walk-away cost. That's what we pay per year in addition to get the base unit of the money.
That does not include the base unit.
That's not.
And as I said, the base unit is certainly an ideal addition to the overall system, especially related to the forensic population. And what Superintendent Harper mentioned in particular is to be able to conduct that assessment of an individual outside of the hospital to determine the behavioral issues and needs, to do a comprehensive assessment, and then determine the best location to provide that care. That's the ideal. That was a much more comprehensive proposal that needed a lot more analysis and debate with the legislature. The creation of the 14 to 16 bed secure treatment facility was was focused entirely on this issue of CMS's concerns that we have a number of individuals in the hospital who do not require hospital level of care. And that's where the documentation in the medical records of that one condition, when they came back in June of 2014, when we had reapplied to become certified, and we had fulfilled all of the conditions for quality, for safety, our governance model, everything. The one condition that they found us out of compliance with was the medical record. And it related to how well we were documenting and demonstrating active treatment. But if you are in a hospital and you don't require hospital level of care, it's difficult to document active treatment in the medical record. And again, Jay, if you want to elaborate any further on that, but that's where it really became identified by CMS of their concerns that we're trying to manage these individuals who don't require hospital level of care through a hospital approach. And these
I think that basically we found ourselves going into that last set of surveys just after I had come on board, looking at all the things that they were mostly concerned with, and we were nailing them all down. As a result, we got to just the one deficiency. So it's kind of like a long dance, and then you get to the last dance, and then the bottom line was, no matter what you do, no matter how good you are, as long as you're serving a population that does not need to be in a hospital, and you're asking us to pay for a hospital, we will not do this.
So the $3.8 million buys the secure unit, not the basement. It's a
Right.
secure facility. But does that include construction and everything else? I mean, this doesn't seem like much money. How does this all get paid for? How does the actual formulation of this place get paid for?
So it frankly isn't a lot different when you think about the fact that when individuals today are granted permission by the court to leave Riverview, there certainly are facilities today that are supporting them with 24/7 services and supports that we contract for. And that similarly would be how we would structure this, only it would be a secure treatment facility. And these individuals would not have, they'd still be under the custody of the commissioner. They would not have community privileges. They would not have been granted any additional privileges by the court. They simply would no longer be in a hospital level of care.
That's very helpful. Thank you.
Representative Grant.
Thank you, Mr. Chair. I would like to just take a moment to be specific about some of the details that I would like to see in moving forward, addressing Representative Timberlake's and Representative Tundo's concerns around where do we go from here. Appreciating the 8-page PowerPoint that we had in May of this year with the pieces of the puzzle drawn out for us in skeletal form. In addition to that, I would like to see some information on the research basis for this kind of separation and a direction. If it's the case, accepting that this problem is a societal one that has grown up around us, as you said, Mr. Harper, and I think I agree with you, there must be research on the efficacy of various kinds of treatment and various modalities for folks suffering from persistent mental illness. I would like to see that. I would like to see some details around the base unit, how it would be designed, how it would be fleshed out, the research and medical basis for that design and its operation, as well as some details around how folks will be triaged. For example, we can't make an assumption that just because someone is forensic, that they don't need a hospital level of care. So we need to understand that process. We need to understand what are the professionals in the state saying about the direction we should take in the care of this population. We had a one-day public hearing with the DHHS committee, looked briefly at the testimony. We had advocates who were against the proposal. What is the basis for this direction? How do other professionals in the state feel? And how does it fit into a more comprehensive continuum of care for folks? Also, I'd like to see a financial outline, an analysis of the money issue. if we're going to not receive CMS certification, or if we're not going to worry about CMS certification, what is the cost analysis around those kinds of decisions? And again, other states have also dealt with this issue. Someone asked about that earlier, Representative Sanborn asked about that earlier. This should already be researched as we go into deciding how we want to go here in Maine. So that's, I guess, at least some outline of the kinds of details that I would like to see the DHHS committee review and the legislature review before we went in this direction. I don't think it needs to be an onerous process or, take a 10-year study. I just think we need to have some answers to some of those very basic questions. And I think you have those answers. And some of them maybe you do need to do a little more research. But when I say we need more details, those are the kinds of specifics I would like to see.
So I think a couple of points that would be very helpful to just frame up parts of this discussion that are really actually already resolved. The first is what we're doing is moving from thinking of how we work with the patient as a hospital. 16 beds, the way to think of that is it's a rehabilitation type of program, not a hospital treatment program. It's the same as if you went in for heart surgery, the insurance company, the doctor said you need to be here in intensive care anymore, and we can step down programs until you're able to be out. So what you're going to do is go from the most intensive hospital level treatment to the point where the courts and us agree that you can go into this rehabilitation type of program. The statute allows the commission to place the person once they have a program and do it's acceptable. In terms of the actual specifics of the program, every one of these people is coming from Riverview. They are a class member. The consent decree determines for both who's in the hospital and everybody else in the class the types of services that they must be provided to make available to them. Now, class members under the rights rules have the right to refuse treatment. So there is this back and forth that always occurs no matter what physical facility you're in. So some of the answers are already there. Don't think of it as a hospital because that's not what we're doing. Think of it as a rehabilitation program. But the rehabilitation program still needs to comply with the basic tenets of the consent decree and the rights rules for recipients. So a lot of that description is already there.
I just want to follow up. And the other follow-up I have, we talk about it a lot and it gets said a lot in this room. Do we know from a specific document or a CMS official, in any official way, that separating these populations would restore our certification? Do we have that in writing, or do we have something that's going to certify that for us?
No, and CMS wouldn't do it. The medical records issue that was raised in that last June 2014 survey is the closest you'll get to their assertion. We can certainly request again that they put that in writing, but CMS is reluctant to do that. I just want to reiterate, we're not here today advocating for the base unit. That bill was heard in Health and Human Services Committee, and I understand it, and died between the bodies. I think there was a Norton report and then perhaps even a discussion about carryover, but that failed. What we have connected to recertification is primarily the 14-16 bed secure treatment facility.
Representative Windsor.
I don't want to go over this much longer. Just, my understanding of the proposal we saw here, that we were going to contract with vendors to create this facility and staff it. So it occurs to me that the department has a pretty robust program of contracting these types of things out. Anyway, why do you need our approval to do that? I don't remember, for example, I'm aware that we're moving a whole bunch of people with brain damage out of New Hampshire facility, and we created at least 3 or 4, 6 or 7 person facilities with varying degrees of security and treatment available for those individuals. And why is this any different? I guess that's my first question. And I don't, need a discussion, I think, loud here, we're not trying to have a debate at all, but I frankly don't understand why the legislature is getting deeply involved in what I would consider a routine contracting program that you do all the time.
It's the funding, Representative, the grading that you identified.
That's a really good thing, but I mean, what we do is part of our normal business.
Right.
With all these populations. Now, some of them, I don't know whether you're trying to qualify some of these people with the Maine care funding or not, if they're just in some rehab facility. I mean, it seems to me likely to do something like that, but you could build that in your base budget pretty easily. 3.5 million or 3.9 million, $4 million budget that's scary.
But we did include that, Representative, in the change package. We identified the funds to be used for this purpose. The brain injury example, that was part of a budget, specifically authorizing the creation of a brain injury waiver and getting the appropriate funds for that.
But you didn't need approval for specifically go out and develop facilities.
Just the funding for the purpose of
So
creating.
that's all you're asking for, funding, and going into the details isn't always that important regarding historical funds.
Well, it is, as I said, it's today, when an individual is permitted by the court to leave Riverview with certain privileges, we today contract and oversee for those services. This would be contracting for a secure treatment facility, if you will, a step-down facility for Riverview. That funding is not part of the mental health budget. In terms of any Medicaid eligibility, just keep in mind that if that 14 to 16, if it is 16 beds, I know this is strange, this is a federal rec, if it is 16 beds or more, and its primary function is to provide mental health services, it would be considered an institution for mental disease, and those individuals would not be eligible for Medicaid.
Representative Sanford.
Yeah, I guess first of all, just a comment on that. As we came around to the end and you're saying that you're really not supporting the base unit at this time, I have to say, this is all about just clear as mud to me now. I understood the proposal back when we were looking at 2 7-bed units for those who didn't need hospital care and trying to get them out of Riverview. There was an op-ed written and published in the Portland Press Herald that attacked certain Democratic legislators and the whole legislature for not approving certain things. I realize that's not the Department of Health and Human Services directly, but it was written by representatives who strongly support the low-page agenda. So, when you started out talking and giving all of this history, you were still talking about this base unit, and now you're saying we don't need that. We're talking about the forensic patients. First that they all need to come out of Riverview, and now only those who don't require hospitalization. So I'm not asking you because I know that the discussion has gone on and on. I just want to say I'm hoping that you can come with answers to a lot of the questions that Representative Grant has asked, perhaps in front of Health and Human Services in October. I understand you're going to have a meeting and have a more specific plan of what you really do want and see and need, to fix the problem, along with options that other states are finding are working for them. So that's just my comment. It's just not at all clear. And secondly, we haven't gotten to the workers in Riverview and their safety and these monthly reports. I can see that there's attached in the information report that goes through May, but it doesn't have the numbers of June, July, and August. we might have been sent those individually, right? If you look at March through May, the numbers actually went up rather than down in regards to injuries reported, so it's really important to have the rest of that picture. And I also understand that you're still in the process of hiring all of these people to try to make this work well. So it just would be nice to be able to follow the trend, and I realize we haven't had time to get that, and as Senator Valentino said, that was supposed to be part of our the information that we got today.
So I'm just going to end with, we have provided information, we have answered questions, we have provided details. I understand that you are not dealing with this day in and day out as we are. I appreciate the request for additional information. The point of just providing background on the base unit was just simply to look at the total array of system issues and challenges that we've been seeking to address. I simply clarified about the secure treatment facility as it directly relates to certification and to just distinguish between those two proposals. Happy to take a look at and respond to the research that you've requested to get a better sense of what is occurring nationally. Do you want to, anything else?
Are you prepared on the substance abuse contracting? Or is there something prepared on that? I've got that on the list here, substance abuse contract.
Alan Borges is here to request that identification finance.
All right.
Okay.
Thank you. Thank you. And I apologize to DOC. I think due to blood sugar levels, after we're finished up on this subject, we're going to take about a half-hour break, grab a bite to eat, and we can come back in. Good afternoon.
Good afternoon, Senator. Good afternoon, Representative Rotunda. Good afternoon, many members. I'm Al Porches, Deputy Commissioner of Finance for the Department of Health and Human Services. I understand committee members have questions on contract the department has with the Maine Association of Substance Abuse Programs. Naturally, I'm happy to answer those questions. If it's helpful, I can go down and give you a bit of background so we're understanding first.
Background, anybody? I got some nods. Please.
Sure. So the contract in question is one of 8 contracts that the department has with the Maine Association of Substance Abuse Programs, that is otherwise known as MASAP. We consider this a staff augmentation contract, and like all of our contracts, it's one that the department reviews on an annual basis or even more regularly to see if it fits with our needs in terms of serving our mission to the neediest and most vulnerable of Maine. This contract in particular, the best way to think of it is, I think, for good understanding is in 3 iterations. So the first, I would say, is what this contract looked like in FY15 and how it would have looked exactly had we gone forward with just a straight renewal in FY16. Second iteration is the actual renewal that we put in place. That's the contract that right now is in place. And then the third iteration is how services will look and what our plans are once that contract expires on December 31st. So first iteration, that's the FY15 version of the contract and what it would have looked like in FY16 had we not altered it. That was a $699,556 contract. It funded 5 positions, again, for staff augmentation at $368,754. We had a prescription monitoring program position, a treatment specialist liaising with the criminal justice system, a data quality specialist, and then coordinators for the Maine Alliance to Prevent Substance Abuse and the Maine Alliance for Addiction Recovery, known as MAPSA and LAR, respectively. We also had $150,927 for consultants and $179,875 for direct and indirect expenses. Direct would be rent, utilities, maintenance of any fixed assets. Indirect would be salary for ASAP's executive director, other administrative salaries, and so forth. So that was what that contract looked like in FY15 and what it would have looked like had we gone with a straight renewal in FY16. The contract that we have put in place is now a 6-month renewal that will expire on December 31st. The new contract eliminates most of the consulting services I mentioned, but otherwise just splits the previous contract in half. Going forward, as of January 1st, the department is taking 3 positions, the first 3 that I described, bringing those in on a limited period basis, the Office of Substance Abuse and Mental Health Services. The second 2, and on those positions, again, you have your PMP coordinator, a liaison with the criminal justice system, and a data and quality assurance manager. So those are 3 that will be brought in to the department on a limited period basis. The other 2, you had the MAPSA and MAR coordinators will be covered internally by the department. We are either repurposing resources there or just recognizing the existing duplication already. When it comes to MAPSA, we have our SAM substance abuse prevention team that's in place, and then with MAR, that's the 5-person SAMS recovery team. So those are how things look. The annual cost, again, of the contract, just to deal in a dollar standpoint here, would have been $699,556. Going forward, repurposing existing resources and adding those 3 limited period positions, that's $237,050. So you're looking at an annual savings of about $460,000 going forward. And again, we'll make this transition as of December 31st.
Yeah, maybe it's just that I'm so distracted by the previous conversation that it was hard to listen to that with a lot of letters. And can we have something in writing that explains that again so that we can really read through it?
Yeah, happy to do that. Are there any specific questions that I can answer out of what I laid out?
No, it's so fuzzy in my mind right now that I can't even ask an intelligent question about it.
Thank you very much for being here. And I know there were a couple other questions that went in on Friday having to do with the audit and the nursing home overpayments. So we'll look forward to getting that information from the department as well.
Yeah.
So those questions were late to come in, but those are other issues. And just sort of one broader topic around all this, and it ties in with the canceling of contract and learning about the audit and the nursing home overpayments. As a member of this committee, it's frustrating to find out what's happening on these fiscal issues from the newspaper and not from the department. And we can all work on better communication going forward so that as legislators with the responsibility that we have, we're not finding out about all of these things in the newspaper, but rather we can find out about it from the department and better communication. We really appreciate it.
Yeah, and we certainly hear your concern there and share it as far as wanting to have open communication. I guess in this case, and I'll take those as 2 parts because we're talking first about the contract. The department has more than 1,000 contracts. We review each of them on a regular basis as to whether they're serving our mission to the people of Maine. So we do make adjustments to contracts, and certainly more than this one. We're more than happy to answer questions. I try to lay out as thoroughly as possible what we did, why we did it, what the plan is going forward. But I don't think it would be our intent, just recognizing our own executive authority to alert the committee to ever change the contract, and I simply couldn't promise that or else I'd be failing. When it comes to the OIG audit, I think that's a matter, and we will respond to that question in writing, but I do just want to say, and this is really on behalf of the civil servants who are doing the work at the department, the title of that audit finding is very misleading, and I think the newsworthy nature of it is not nearly as significant as the way it was presented. The The title of the audit says that the department failed to implement both recommendations of an OIG finding from several years ago. That's actually not true. And if you read the finding, you'll see there were two recommendations. One of them was that we repay $1.09 million in federal funds. We did that because we're in nursing facility overpayments. We were to repay the $1.09 million, and we did. It says so on page 3 of the audit finding. So what they mean by both is that we didn't implement each. Their second point was that we haven't developed processes and procedures to ensure that we don't have overpayment problems going forward. In fact, we have. They may disagree about the timeliness of our implementation of those processes and procedures, but we absolutely have. And the commissioner's letter responding to the finding is right in there. The amount of money overpayments in question I think is really important here for context, and this is why it was not communicated to our representative on time. They're talking about $4.4 million in overpayments over a 2 3/4 year period of time, July 2010 to March 2013. During that period of time, we paid nursing facilities more than $586 million. 4.4 million in overpayments is less than a percentage of that. It's 0.75%. That is almost de minimis. If we were to alert you to every sort of fluctuation like that in the department, again, I think it would be constant. Frankly, I think it would be a waste of your time. I have a lot of confidence in the processes and procedures that we put in place. If you look at the 4 rounds of overpayment collections, taking that money back in that we've had, the 3rd and 4th rounds have been particularly impressive. The people doing this work are all civil servants. I think they're really doing an outstanding job, and I was personally disappointed in the title of that audit finding and the way it was subsequently reported, because I think it created a lot of confusion that didn't need to exist about the type of work we're doing in the department.
Thank you, and thank you for that. I'm looking forward to getting that explanation in writing as well. I guess it just leaves me wondering, is there anything else happening in the provider system that we're not hearing about, that we should be hearing about?
No, I don't think so, but we absolutely do want to keep open lines of communication in our committees.
Thank you. I just wanted to comment that your argument about this being such a small percentage of the amount that is paid out is so similar to what I believe happens in the welfare system, is that it's a very, very small amount of fraud that occurs, and yet continually we are beat up about the amount of fraud and the cost of fraud, so that if I run into any constituent, they will continue to reiterate what's out there in the news as if there's a huge amount when it's really less than 1% or even 0.1%. I don't know exactly off the top of my head, but it's very, very small. So I appreciate your argument. I agree with that, and how those numbers can get abused. It happens with welfare as well. I also have another question in regards to federal grants that I understand Maine has received in regards to colorectal screening, cancer screening. And I don't expect you to answer that now, but I was thinking that maybe if I could just get that question out there. And I'm wondering if Maine has officially accepted the money from that grant. I think it's important money. I know that there are a number of federal grants that the Department of Health and Human Services has turned down or not applied for, and it really hurts to see that money that we can get and spend well and save money, state dollars, that we're not using those funds well. So my question is whether we have accepted the colorectal cancer screening grant from the feds.
No, I think we'll just add that to the list of questions Representative Sandberg that we respond to in writing. When it comes to grants, we have a very thorough grant review process. We certainly don't turn down any federal money that we think useful to get from permission to people in Maine.
I believe we turned down money for arsenic screening and for lead screening just recently, things that came out after all the work that was done in the legislature, and those are a couple of examples. So there are many of us who care about public health, who have real concerns about opportunities that we're not taking advantage of.
Thank you.
We share your concern about public health representative, and we'll be happy to respond to that question. Thank you.
Representative Fry?
Thank you, Senator. Good afternoon. I want to follow up on two items that came from your presentation today. You had mentioned, so in terms of why the contract that we were talking about may be canceled, I understood there was a repurposing of resources and an elimination of duplication, that apparently duplication that contributed to the work that was being done under that contract. And so, I guess the question is, well, probably, where do these resources come from that are being repurposed? And is it the same amount? Is it a larger amount? Is it a smaller amount? Because if you're eliminating duplication, it would seem to suggest that there's some amount of money that's not going to be spent anymore, because, you know, if you have $2 and $1 is going to be enough to take away that $1, that's a savings. So, if that makes sense, like, where do the resources come from? And they're being repurposed. And how much money is being repurposed in light of the fact that something's being eliminated as a duplication?
Sure. So you have, think about it this way, 5 people under that contract right now, contractors we're using through Mayhew. 3 of those positions will not come over as limited period positions to the department. Those will be initiated as of January 1st, and that's where you're going to see a new cost, less the overall savings of canceling the contract. So annually, there should be about $240,000 versus the contract is approximately $700,000 this year. The 2 other areas where we're eliminating any duplication is with respect to the MAPSA and MAR coordinator positions. We have a substance abuse prevention team at SAM's, Substance Abuse Mental Health Services Office, and we have a recovery team at SAM's as well. One is a 6-member team, and there's a 5-member team. And I think you could make the argument that they're actually fulfilling those duties already. If there's anything that would be, left unfulfilled, that's where the resources would be repurposed. What we really have the resources to do right now is why we have the Office of Mental Health Services. We spent a lot of time reviewing this contract in the spring and early summer, making sure that we weren't going to leave any gaps. And one of the reasons that we renewed it for a 6-month period of time was really twofold. First was on our end to make sure that we could make that transition smoothly, that we weren't rushing, leaving some sort of hole. And secondly was to continue to work with the provider in partnership to make sure that they could make their transition time focused.
So the repurposing resources is not repurposing resources from someplace else. It's repurposing resources from the existing amount that has been budgeted for the contract. Because that's part of the question in your answer to. So it was the duplication side of it, but also you had mentioned that the reason the contract wasn't needed was because they were repurposed resources. I had just understood that as resources from someplace else were coming in to be used to pay for these services. So the contract would be needed, or that money for that contract. So was it just repurposing the resources for that contract for this revised center, or is the resources coming from someplace else altogether that are being used to pay for services that are being provided?
Yes, I think the confusion might be around the word resources. We're just talking internally. Frankly, I think it's just duplication at this point. The reason I use the word repurposing is if we need to cover any services that we're not already covering right now, we'll just continue repurposing the existing resources. But the only additional cost, so very simply in dollars and cents, you've got a $700,000 contract that would have been renewed in FY16. That's how much it cost in FY15. It would have cost exactly the same amount in FY16. The only costs replacing that contract are the 3 limited period positions, and those would be at about $250,000 a year.
And so then the second part of that question, concern I did, is that I think you indicated that somewhere in the ballpark of $400,000 was going to be saved, which sort of makes sense in the numbers we were just talking about. So what's going to happen to that $400,000?
So just to be clear, that won't be saved this year because we're only getting half the year in effect. So I don't want to talk about, annually going forward, that's your savings. It's a little bit less this year given the schedule.
Was it maybe this year? Or?
A little bit more. We're able to use all of the substance abuse block grant to cover most of those expenses. We were able to kind of push that in the front half of the contract as it would have been. So you're looking at a little more than $350,000 in savings, but I just don't want you to expect $400,000 on the dot. We could either repurpose that funding within those accounts, so it's mainly our substance abuse fund. We've got quite a bit of latitude to do that, or it could lapse back to the general fund and into the pockets of the taxpayers in Maine. It's one of those two.
Those are the only two places that it could go. That money could be, I'm just thinking about there is executive branch freedom to sort of money isn't spent, and I think in DHHS maybe we can provide that for you, that money isn't spent, maybe it can be used for Riverview, or it can be used for the DHHS, or it can be used for. There's only two things that can be done with that.
Right now, we've got it in that appropriation, so there are some limitations within that, and we certainly review other alternatives as well if we came to that.
Is there alternatives?
Just like you suggested.
Okay, so there is some freedom to do more than just.
I'd have to check on that particular.
I can't remember. I don't expect you to remember that either. If you're writing something up pursuant to Representative Seymour's request, maybe that could just be part of that as to how that $400,000 would be, or $350. I don't want to hold you to a number. I'm not going to do that. I'm just curious as to what would happen to whoever savings you have.
Yeah, and I don't think we'll have an answer for you today. It's something that's ongoing conversation, but certainly worth exploring the flexibility. The $3.5 billion budget, it's not a tremendous amount of money, but obviously it's important savings. And going forward, all of the savings will be general fund because of our use, a little bit more, I think, informed use of the block grant, if you will. So it's going to be $400,000 in general fund savings on an annual basis.
I think there are smaller programs that would like to have access to $400,000. So even though it might be a small amount for DHHS, I mean, if we have a substance abuse program that's running around $700,000, $400,000 could be a lot of money for some of the things that the legislature appropriates. So that's just why
The individual taxpayers as well.
That's right. Thank you very much for thanks.
Any further? Seeing none. Thank you. Committee will take 30. 30 minutes. Bring it back in at 2:05. Trump? Yes?
Yes.